Good evening, everyone. My name is William Reichman. I'm the Special Magistrate hearing the cases this evening. It is May 25th. It's a little after 5:30 here in the Deltona Commission chambers. We're hearing code enforcement cases brought by the city of Deltona, and we're here to hear the evidence from the city and from all of you on your cases. We do this on a first come, first serve. That's why you signed in when you came in. So even though we have an agenda, we're just going to follow. It's kind of like when you go to Publix Deli and you first come, first serve for your sub. So I'm not trying to minimize the importance of it, but that's a good analogy. The first thing we do is we identify ourselves, all the folks that are here for the city, and I start with myself. And again, my name is William Reichman. I'm an attorney, been practicing law for almost 40 years now, and been doing code enforcement for a long, long time. I've been the special magistrate for the city of Deltona for, 3 or 4 years now. And I'm a private attorney, and I don't work for the city of Deltona. I am appointed by the commission to be a judge, a quasi-judicial judge. So we're going to go around the room and let everyone identify themselves for the city. We'll start to my right.
Richard Lovett, Code Compliance.
Byron San Miguel, Hearing Clerk.
Mark Gibson, Code Compliance Supervisor.
Tyler Rousseau, Code Compliance Officer.
Bashir Turksey, Code Compliance.
Kristen Coulter, Code Compliance. Marion Larsey, Code Compliance.
Dennis Hughes, Code Compliance.
Nelson Nieves, Code Compliance.
Jill Scott, Code Compliance.
Nicholas Lopez, Code Compliance.
Josie Jimenez, Code Compliance.
Ron Paradise, Community Services.
Phyllis Wallace, Public Works.
Thank you, folks. Now, if we could all stand and pledge allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. A couple things you all should be aware of. I've briefly introduced the process. Tonight's a public hearing, but the cases involve the city and of course the respondents, those of you that are here this evening. And the way we do this is called quasi-judicial. It doesn't have the formality of a full-blown trial, but there are certain things we have to do. We don't follow the strict rules of evidence, but obviously what due process means is that you had the right to be here tonight, to testify, to bring witnesses to testify on your behalf. You received notice of the hearing for tonight. Please understand that everything tonight is being recorded. Your testimony will be under oath. I'm going to swear you in a second. If you have documents or photos or any other evidence that you would like me to see, please understand that becomes part of the record, which means that it'll be kept by the city. And if you need to make a copy, you'll need to coordinate that with the city representative. The way these things work is the city when we start calling the cases, the city goes first. They've got to prove their case because they're the ones that are bringing these cases. And the city representative is going to stand right there at that center podium. And when the city's done, then I'll ask you all to come forward, and you're at that podium over there. So with that said, let me tell you that one more thing about the process. I have not spoken with any of you this evening or before. I have not spoken with any city representative about any of the cases tonight, whether it's cases that you're here on or folks that aren't here. I don't know anything about your cases, and so I'll be making my decisions tonight based upon what I hear tonight and what I see tonight. So in our world, we say that there have not been any ex parte communications. So I just want you to be assured that I haven't made up my mind because I haven't heard any testimony, seen any evidence. Couple announcements. You saw, I'm sure there was an agenda that was there for you to review. I've approved that agenda. I've approved the minutes from the last meeting. There's 3 cases that have been withdrawn or continued, so if you hear on those cases, then you can go home. 22156 and 22067 were withdrawn, and the case 22147 was continued. So we're about ready to get started. I'm going to ask everyone who's going to be testifying tonight, providing any evidence, to please stand and raise your right hand, and you'll be sworn in. So your testimony will be under oath. Do you swear or affirm that the testimony, evidence you provide this evening is the truth, the whole truth, and nothing but the truth?
I do.
When your case is called, after the city completes its case, and you come forward, what I would ask of you before you start telling me what you want me to hear is please give me your name and your address. And the reason is it's important for the record to reflect exactly who's testifying so that there can't be any misunderstanding should the matter ever need to be reviewed. So with that, let's get started. The first case is actually 4 cases. It's 1 property, and the property is 2901 Howland Boulevard. And the case's numbers are DEL 22143, 144, 145, and 146. Hang on just a second while I get to that in my agenda.
Page 8.
All right, city ready to proceed?
Yes, sir. Oops, wrong one. That's it. That's it. Okay, my name's Dennis Muse. I'm employed by the city of Deltona as a code compliance officer. My credentials are filed with the city. This is DEL 22143, City of Deltona versus Cole, FD Portfolio 3 LLC, care of Family Dollar Stores Incorporated. Location address is 2901 Howland Boulevard, Deltona, Florida 32738. Parcel ID number is 8130-231-50030. And this is a violation of the City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states that all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in good repair and sound structural condition. Corrective action would be repair or remove the fence. In this particular case, the statutory requirements for this notification for this hearing have been met by a notice of hearing was sent certified mail 10 days prior to the hearing date and posted at the property address listed with the tax collector's office. The notice of hearing was also posted at City Hall at least 10 days prior to this hearing. The notices for this particular 4 cases were hand-delivered to a Dixie, which was the store manager at this location. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was originally a proactive case started back on 10/6/21 by Officer San Miguel. I was with him at that time. We spoke with the store manager and the district manager, Richard McBain. He stated that he would need some time to get these issues corrected, and this fence in particular. Email was sent by Mr. McBain following our meeting with him, and he stated pretty much the same thing, that would be Exhibit F. The case was given to me on 10/27, and the hearing, of course, was mailed out on, the hearing, notice of hearing was mailed out on 5/10 of this year. As it stands right now, the fence is not in any better shape than what it is now. It's still hanging down this part here, and then there's one other section that does have a piece of a log or branch hanging on it.
So you're telling me the current condition, and when did you last inspect the property?
Today.
So what you saw today is reflected by that photograph?
Yes, sir.
Okay. When was that photograph taken? Does it say on there?
This one here, Yeah, I don't have a, for some reason, I don't have a date on this.
That's not, you didn't take that today?
No, not today, no.
Okay. The one in the file says it was taken on March 20th.
Okay. I'm sorry, and as of, right now, the city is asking for 30 days to get this repaired, or a fine to start thereafter of $100 a day.
So do you have anything further?
Not with this one, no.
Okay. Remember now, we're only dealing with case DEL 22143. This is the accessory structure. What we're dealing with is this fence issue.
Yes.
Is there anyone here this evening for the respondent, property owner at 2901 Howland Boulevard, identified in the agenda as Cole FD Portfolio 3 LLC, also known as Family Dollar Stores, Inc.? Is anyone
I
here?
have the attorney, Josh Smallwood. You can come on.
This is your moment in the sun.
Thank you very much.
Do you have a representative?
Yes. My name is Josh Smallwood. I'm from the law office of Mr. Sarowitz, address 6921 Pistol Range Road, Suite 101, Tampa, Florida. And I'm here on behalf of Family Dollar, who is the tenant of the location. Family Dollar, first of all, would like to apologize for the code violation and would like to work with the city as much as possible to get that remedied. I know that some time has passed since that original violation. However, that fence does not appear to be along a route that has any significant foot traffic, so it doesn't pose a hazard. It also doesn't appear to be caused by anything other than just the fence falling down. I'm not exactly sure the exact reason for it. So in that light, because it's not an immediate danger, I'd like to ask for 90 days before a fine starts to ensue, and as well a fine of only $25 a day if a fine should ensue. And Family Dollar will do everything that it can and is showing good faith by having a representative here at this hearing, and would like your consideration.
So is that representative here? You said there's someone from Family Dollar?
Yes,
Yourself?
Yourself, yes.
Is there someone who, like the store manager or someone else that's here this evening?
No, I'm the sole representative.
Okay. So you haven't been out to the site. You don't have personal knowledge.
I was able to visit the site this afternoon, and it does appear significantly the same as it is in that picture.
All right, so we don't have an issue of whether there's a violation. The issue is, how long are we going to need to fix it?
So,
Right? That's what I'm hearing. That's what I'm hearing. You're the issue you're raising this today.
yes.
Okay, so let's talk about the violation. So it's from the photographs and from the descriptions, and then from hearing your testimony. But this question for the city first, and then for you, sir. That fence, is that a fence that would, because the city has said that to correct the violation, either needs to remove or repair the fence.
Yes, sir.
Well, that fence is leaning up against a brick wall, a concrete brick wall. So where did that fence come from? Because it's just leaning against the brick wall, the
Well,
concrete.
that is actually posted up on top of that wall. And if you look at the second post in, you can see it's like cemented into that one block.
So it's on top of the concrete block?
Yes.
Okay. So let me ask this. You got a pretty tall concrete block wall, and you got a fence over it. What's the purpose of that fence? Is that required by code?
No, that was actually put in by the contractor when they built that establishment.
Okay, so they could remove it and still be within code?
I would think so, yes. But it is quite a drop.
Say what?
That is quite a drop there. If some kids ever got up there and decided to clown around, they could fall.
Is your client's intention to fix it as opposed to take it away?
I spoke with Officer Muse yesterday. I believe, as I understood it, that fence is along a retention wall, and as he said, there is a significant drop-off there, so it was put there by Family Dollar as, a preventative maintenance measure, so somebody, wouldn't fall off the wall, as we were discussing. So as I understand it, it would be Family Dollar's intention to repair the fence as opposed to remove it, because that fence does go along a significant portion of that back retention wall. However, I don't know that firsthand.
So what's on the other side of the wall? The building, Family Dollar's on the right, correct, in that photo?
In that photo, yes.
What's on the other side of the wall? What is it preventing access to?
As far as I know, it's a wooded area. Maybe Officer Muse would know more about what's
It's a
over there.
wooded area.
Okay, fair enough. It's not like a lake or anything like that. So this question to the city. So the gentleman for Family Dollar saying that his client would like not 30 days but 90 days. What's the city's position on that?
Your Honor, if I may interject,
You're with the city. Absolutely, you may.
I believe that there may be a code requirement for the fence on top of that wall.
Right. That's what I figured.
Yeah, I'm not an expert on some of these code requirements when it comes to the building code, but I think there may be a code requirement.
Well, and that's actually relevant because the testimony from the city, so prior to yours, sir, was that compliance would be either repair or remove. And if compliance is not removed, then that may be a factor in how much time is necessary to gain compliance. Okay, so my next question is to the city. How long have you known that the property's been in disrepair?
Since October 6th of last year.
Okay, and when did you first contact a representative from the property owner about this?
October 6th of last year.
Okay, so it's almost June. So it's been 8 months. That's 8 months. Why do you all need 90 more days?
Unfortunately, in companies like Family Dollar, there's significant, bureaucracy, and it's difficult for people like the store managers, people that live and work in the community, to be able to get it to the appropriate people to have, something like this fixed. I'm not aware of how much time or what type of contractor it would take to fix this type of thing. But in that sense, I like to liken it to, 7 or 8 months have passed, and in a bureaucracy like that, it could be more likened to 7 or 8 weeks for things to get rolling. That's why we would ask an additional 90 days.
All right. What's the city's position on that?
We could understand there may be where they're going to have to get estimates to get it done. But I think 60 days would be plenty.
Yeah, I kind of agree with the city. I think 60 days is enough time. You're not rebuilding a block wall. You're just reinstalling the fence. So I think that's plenty of time. And I'm just going to tell you from a standpoint of the fact that it's been 8 months already, that's a lot of time. I mean, clearly, if you'd started on October 6th of getting this thing remedied, we wouldn't be having this hearing. There's no doubt about that. So I'm going to say 60 days and a fine of $75 per day. If this fence isn't fixed by the end of that 60 days from today, okay? So that's 60 days or a fine of $75 per day. So the next case is DEL 22-144, same parties. This one says it's about debris.
Give me 1 second. Okay, my name's Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. My credentials are filed with the city. Case number DEL 22-144, City of Deltona versus Cole FD Portfolio 3 LLC, care of Family Dollar Stores Incorporated, location address of 2901 Hallam Boulevard, Deltona, Florida 32738, parcel ID numbers 8130-231-50030. Violation of City of Deltona Ordinance Section 38-110-2, which states that the accumulation of waste, yard trash, rubble, and/or debris are declared to be a nuisance and must be abated. Corrective action, dispose of properly in a certified containment area, store inside a enclosed building. The statutory requirements for this notification have been met by a notice of hearing was sent certified mail 10 days prior to the hearing date, was hand-delivered to the store manager, Dixie. The notice of hearing was also posted at City Hall at least 10 days prior to the hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. Again, this case was a proactive case that started on October 6th of 21. At that time, there was trash and debris throughout the property, especially in the rear of the property where someone had been feeding cats. Multiple empty cans of cat food and water bowls were present along with debris inside the containment area. The district manager, Richard McBain, stated that we'd have the lot maintenance crew clean up the property. A follow-up email was received from Mr. McBain stating that they were working on the violations. The email is Exhibit F again. The case was then given to me on October 27th. As of today, the property has been cleaned up some. There is still debris, as you can see, in the containment area. As far as the cans in the overflow sewage area, most of them have been cleaned out. There are still some in there. The back of the property still has water bowls and several cans of empty cat food. Debris is throughout the whole property, though. Their maintenance crews do come in every so often, and they do clean up, but they seem to leave a lot behind. As of today, pretty much what you see there is the same. A couple of those pictures were taken just a few days
So
ago.
go back to that last photo. It looks like concrete.
Yes,
You went out to the property today. Is that the way it
Today.
looks today?
that's the same way it is today as it was on the 22nd.
Okay, go to the next slide.
That's,
So you're asking me to look at what's behind that
yes,
fence?
yes, that's the containment area where they keep their dumpsters, and that's how it's been looking.
And that's the way it looks today?
Yes.
Okay, next slide.
We'll find that. I gotta go back. This is the back behind the containment area.
Okay.
Some of those cans have been removed, not all of them. There's, the grate has been lifted off. From what I've been told, the grate was lifted off by the fire department to, I guess at the time, they were afraid there were some cats in there. Cats have access to that in and out, so there was actually no problem. But somebody's been dumping the cat food cans down there in order to feed the cats,
Okay.
and that's where they leave them.
What's the city's request?
We are requesting 7 days to have the property cleaned up, or a fine of $100 a day.
Thank you, sir. All right. What is the property owner, or actually, you represent a tenant?
Yes, Family Dollar, the tenant, yes.
That's your client?
Yes.
Okay. So what do you have to say on this case?
Do I need to announce myself again, or just?
No, sir. It's all the
Okay.
same case. You haven't changed in 5 minutes, so I know who you are.
Yeah. And Family Dollar does not dispute that there is trash on the property. I think Officer Muse, if he's been out there today like I have, knows that the debris is mainly in the back of the property. It's not visible from the road that I know of. It also appears from the debris that's in the picture. And the cat food, obviously, is not something that's incidental to Family Dollar's business. I'm not sure if you know, what exactly the circumstances are. Obviously, you know, picking up trash is not the same as having to repair a fence. However, that rubble, I would like to make a note of. If that's concrete, I'm not sure. I just want to be clear about what the city is asking. Is that to remove that rubble?
Yes.
Or is it to
Yes.
repave?
No, we just have it removed. It's just broken up piece of, it looks like asphalt.
Okay.
I mean, I don't know what's underneath it, and I'm sure the city doesn't know what's, I mean, there could be another issue that could arise once that rubble is removed. For purposes of what we're trying to accomplish this evening, we don't care about that. For purposes of tonight, that's what the city is saying needs to be removed, period.
Right, understood. Like I said, obviously this is not the same as repairing a fence. However, we would still ask for a longer period than 7 days because there is significant debris, and just to make sure that everything is brought into compliance, considering the fact that they're asking for a fine of $100 a day. We'd also ask that the fine be reduced to $25 a day if there does have to be a fine. But
So how much time are you asking for?
we would ask for 30 days.
What does the city have to say to that?
2 weeks, maybe $50 a day.
Yeah, I think 2 weeks, that's 14 days. That's 14 days. It's been going on since October as well. And I know that some work has been done. Appreciate that. You're here, appreciate that. But this has been going on since October. And so the violation's there, and it's been there. So I'm going to say it's 2 weeks. That's double what the city's requested. So that's 14 days. And we'll reduce the city's request in half to $50 a day. And of course, I know you know this, but please understand that these cases are not just brought against Family Dollar, but also against property owner. So if there's not compliance, there'll be a fine brought against property owner, which is your landlord, which is not a good thing, because I'm sure there's some provisions in your commercial lease for consequences for code enforcement liens and things like that. So I would encourage you, and we've got 2 more cases, but just getting a little ahead of myself, I would encourage your client that as soon as there's been compliance, timely compliance, please contact Officer Muse so that we don't have to go down that road.
Yes, understood.
Okay. All right, we're on the next case. Same party, same property, different violation, 22145. This has to do with sidewalks and driveways. Officer Muse.
Okay, my name is Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. My credentials are on file with the city. Case number DEL 22145. It's City of Deltona versus Cole, FD Portfolio 3 LLC, care of Family Dollar Stores Incorporated, 2901 Howland Boulevard, Deltona, Florida 32738. And parcel ID number is 813023150030. The violation is ordinance section 18-5, which adopting the latest edition of the International Property Maintenance Code, section 302.3, for sidewalks and driveways, which states that all sidewalks, walkways, stairs, driveways, parking spaces in some areas shall be kept in proper state of repair and maintained free from hazardous conditions. The corrective action is to restripe the parking lot to clearly define the designated parking areas. The statutory requirements for this notification for the hearing have been met by a notice of hearing was sent certified mail 10 days prior to the hearing date and hand delivered to Dixie, the store manager at the location. The notice of hearing was also posted at City Hall at least 10 days prior to the hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case here, again, was started back in October 6th of 21. Again, the district manager, Richard McBain, was there with the store manager, and he stated he would get the violations corrected.
When was that meeting you're describing?
That was on October 6th.
Okay.
We happened to catch him there at that time. And he followed up with his email, which was Exhibit F. The parking lots are pretty much non-existent. The front of the store and one little section on the side of the store, you can see some lines. But over and all, there's basically nothing there.
You're not saying the parking lot's non-existent, you're saying the striping
The
is
striping is
Okay.
non-existent, yes.
Because I can see the parking lot.
Yes, sir.
Okay. So this is about the striping?
Yes, sir.
Okay. I get it. What's the city's request?
The city's requesting on this one here 30 days and a fine of $100 a day thereafter if not complied.
I think you've got a pretty good idea where we're going on this case, but I'll listen to whatever you want me to hear.
Family Dollar would agree that that is the appearance of the parking lot at the time. However, as Officer Muse said, there is some striping, especially up front, and it appears to be where the handicap spaces are. So there is striping in those locations. It also appears to be, from what I saw today and from the pictures, a large parking lot. It doesn't appear to be being used to capacity. It doesn't appear, therefore, as a hazard to vehicles at this time. And because it's significant, such as the fence was, and it's not just cleaning up debris, Family Dollar would like to ask for 120 days to remedy this situation. And also a reduction in the fine to $50.
Okay. Let me see if I can digest that. So you're saying that it's your client's position that really doesn't create a hazard, which reduces the need to get this fixed, but, and correct me if I misheard you, but that this parking lot often fills to capacity.
No, I apologize if I was unclear. I'm saying that the parking lot doesn't appear to be being filled to capacity,
Okay.
so therefore...
I misheard. That, you probably did say that, so I apologize. Well, that's fine. But the striping requirement's there for a reason. And it's
Yes.
to prevent folks from, hitting each other,
Right.
opening the doors on each other. It's a part of the land development code. And I keep coming back to this issue that the city met with the district manager and with your office, or the store manager, on October 6th. October, November, December, 3, 5. Okay, it's almost 8 months. And I get it. There is a need to go out and hire somebody. My guess is that I'm just giving you the basis for what's going on with my reasoning. I mean, the Family Dollar store is not a mom and pop organization. And I don't know if this store is a franchise or if it's a company store, but my guess is that you've got a lot of different contractors that you work with on a regular basis, if not on speed dial. So, I don't know that one way or the other, but this is not like Mr. and Mrs. Jones and their property that have to, start from zero. This is your client's a commercial business. So the city's asked for 30 days, and you've asked for 120. 120 is 4 months. I can't do that. Does the city have an opinion on this?
Again, with getting estimates and such, we could probably stretch out to 60 days, but still keep it at $100 a day.
All right, I'm going to give it the 60 days, and we'll reduce the fine to $75 per day. So you have 60 days, or there'll be a fine imposed, which could become a lien, and the per diem would be $75 per day. Okay?
Understood.
Okay? Last case, the DEL, this is same party, same property. Last case for this property is DEL 22146, and this has to do with erosion.
Yes, sir.
It says on the
One sec.
agenda.
Okay, again, my name is Dennis Muse. I'm employed by the City of Deltona as a code compliance officer, and my credentials are on file with the city. Case number DEL 22-146, Cole FD Portfolio 3 LLC, care of Family Dollar Stores Incorporated, 2901 Hallam Boulevard, Deltona, Florida 32738. Parcel ID number is 8130-231-50030. This is a violation of the City of Deltona Ordinance Section 98-77B, subsection 3, which states, notwithstanding any other provision of this article, there shall be no harmful erosion by water of any soil or fill into any adjacent public or private property. Corrective actions repair the water drainage erosion on the west end of the property from undermining the foundation and replumb the stormwater to the retention area in the rear of the property, regrade the west end of the property, and resod. Statutory requirements for the notification of this hearing have been met by a notice of hearing, and hearing was sent certified mail 10 days prior to the hearing date, posted at the property, address listed with the tax collector's office. Notice of hearing was also posted at City Hall at least 10 days prior to the hearing. This notice was also hand-delivered to the store manager, Dixie. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. Again, this one didn't start on the 6th. It started at the end of the month, which is about October 27th of last year when I did receive this one. This came in from the Public Works officer, directed me out here to have me witness this. I did see it. Yeah, we did see it toward the beginning of the month, but didn't realize how bad it was. But from those last few storms that we've had, it's gotten a little bit worse. If you look at some of the downspouts, the one toward the back of the building has really eroded away the ground. Now with the fence hanging down there, it's acting more or less like a dam because it's collecting debris, and it's washing out where that green pipe is that you've seen. And it's washing quite a bit of the soil and sand down into the retention area. With that being said, the city is looking to get this finished and repaired in a 60-day period.
So it still looks like that today?
It still looks like that today, yes. And we're asking for $250 a day thereafter.
How many, 30 days, you say?
60.
60 days,
Yes, sir.
or $250 per day. Okay, sir.
Family Dollar does realize that that is the state of the property right now. However, this is, as we've heard today, this is a little bit more involved of a project, especially given the pictures that you're seeing right now. It's not as clear what would be in compliance as, say, repairing a fence or cleaning a lot in that light, and because that it appears from the pictures and from the testimony that it's just a lack of maintenance. It's not something that's been willfully done by Family Dollar. Family Dollar would request 120 days to remedy the situation, and hopefully will meet with code enforcement before that in order to make sure that everything is in compliance, which is the reason for asking for 120 days instead of 60 days as the city suggests. We would also request that given the gravity of the situation and since it's more than a lot sweeping, Family Dollar does take this seriously, but they'd still request that should the property not be brought into compliance, that the fine would be $100 a day instead of $250.
All right, this is just a generic question to either of you. This looks like it's on the side of the building.
Yes,
Yes,
side or
Because,
back.
one of those photos looked like there was a car where it's the front parking lot,
Yes, sir.
which needs striping. But it's the front, it's on the side. So these look like irrigation lines. There could be actually potable water lines, but there was one picture in here, that maybe that's it, but there's another one in there that shows that these are pretty deep and it's actually impacting foundation issues, which of course I imagine as a landlord, could be a landlord concern. Did you have any conversations, Officer Muse, with any representative of the property owner or the tenant on this issue?
On this particular issue, it was just the store manager, which she stated that she was putting in work orders for this and the other violations that same day.
Let me stop right there. See that green pipe? Do you know what is that pipe for? Do you know? Right there in the photo.
I got the deputy director here for Public Works. She could probably tell you better than I could.
That is their sanitary sewer line.
Okay.
And the white pipes appear to be based on looking at as-built drawings. their fire protection line. So there is some concern. I believe the larger white PVC pipe is their fire line. So there is some concerns that if
Yeah.
those pipes fail, you now have more than just a stormwater erosion or foundation erosion issues.
Yeah. You know, let me say this. I mean, when you had the litter and the fence and the other issues, you know, that's mostly appearances, mostly, although there's a little bit of safety issue there, but mostly appearances. Okay. This one, arguably, in the worst-case scenario, could be worse. First of all, most people shouldn't be going back there, but if you've got kids running around there in the dark, they're going to trip, they're going to fall, and they're going to get hurt, and someone's going to get sued, and someone's going to go to the hospital. And none of us want that. Number two, get people out there, they're up to no good, and they go out there and they cut that line. And you don't know that they cut that line. Well, now you don't have water in case there's a fire. Again, my job is just think about, and for purposes of making my decision today, what's worst case scenario? Someone goes out there and they do something stupid and they break that sanitary sewer line, and you don't find out right away. Well, there's going to be a big spill out there, and that's not a good thing either. So to me, this one probably, of all the cases we've heard today in this property, sir, probably gives me more concern. So for that, I am going to say that it's 60 days. Now, you said, well, what needs to be done? Well, what I'm hearing, and from the city, and just looking at it, what the city said is it needs to be bring in some fill, you regrade it, and you put sod over it. Fair enough?
Yes, sir.
Okay, so it's not structural. It doesn't matter bringing in a dump truck full of dirt and getting one of those little you know, fancy machines and move the dirt and cover it over and bring in some sod. And I think 60 days is enough time to do that, since it's been going since the end of October and because of the reasons that I say. Now, I am going to reduce the fine to $150 per day, but this one gives me some pause. And I will tell you that you know, I've been doing this for a while. That is one of the major concerns that I have when I'm making these decisions, is safety, environment, human beings, that sort of thing. So that's the reason so I would impress upon you to please get with your clients to obviously we don't want to fine you. The objective here is compliance.
Understood. Thank you
Okay.
very much.
Okay. All right. That's it for that property.
All right, thank you, sir.
Okay, we have two cases, one property. It's our next one. That's DEL 22154. This is Officer Nieves. And 22155. The two cases deal with 902 Roberts Boulevard. Property owners are Victor and Henry, and I apologize if I mispronounce this, Alicia. And the first case is 22154 and has vaccination against rabies. Officer Nieves.
That first case was actually in compliance, the rabies, against rabies vaccination, sir.
So are you telling me that DEL 22154 is in compliance?
Yes, sir.
Is the city withdrawing that case?
Yes.
That's fine. Just want to make sure, because, you know, going once, going twice. Okay, so I'm going to note for the record that the city is withdrawing case 22154. That means we will proceed with case 22155, which deals with spay and neuter.
Okay. My name is Nelson Nieves, and I am employed by the City of Deltona as a code compliance officer. This is case number DEL 22155, the City of Deltona versus Victor and Henry Alicia. The property address is 902 Roberts Boulevard, Deltona, Florida, 32725. The parcel ID number is 813-028-160-200. This is a violation of the City of Deltona Ordinance, Section 14-238B1, which states that no person may harbor, a dog or cat 6 months of age or older within the city that has not been spayed or neutered unless such person holds an unaltered animal permit for each unaltered dog or cat, or unless the dog or cat is otherwise exempt under this section. The corrective action for said violation is to spay and/or neuter the animal. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a case that I had received from a written complaint regarding a dog that was defecating on the neighboring properties. Upon my investigation, there was no case on file regarding the mandatory spay and neuter. And per the city ordinance, all dogs and cats 6 months or older must be spayed or neutered. I had posted the notice of violation on February 25th, where later I had called and spoke with the tenant regarding the spay and neuter. I was told that an appointment was made for May of this month, where I called the Central Florida Community Pet Clinic, and I was able to verify that there was an appointment indeed made for this month, the 31st, for one of the dogs by the name of Stormy. Now, as of today, I haven't had any other further contact with the tenant to verify an appointment for the second dog.
So, there's 2 dogs.
Yes, sir.
This case is about 2 dogs.
Yes, sir.
Okay, could you identify the 2 dogs?
Stormy and Onyx.
Okay. Names are great, but I need you to tell me are these purebreds or are these rescue dogs?
I have one here that's an American Pit Bull. That one is Stormy, and then Onyx, I have here, it says, I think it's mixed breed.
Okay. Now, am I hearing you say that as far as you're aware today, neither of these 2 dogs, and that's what we're here on today, have either been spayed or neutered?
Yes, sir.
Okay. And that you were aware that there was an appointment for that to happen at the end of, or what was the date that you said that there was going to?
5/31, the end of this month, the 31st of this month, sir.
31st of this month. So it still could happen.
Mm-hmm.
But right now, it hasn't, as far as you know.
Yes.
Okay.
I was able to verify.
Okay. So what is the city asking for?
The city would like to request 30 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay. And the individuals identified in the agenda are Victor and Henry Volusia?
They're the property owner.
They're the property owners. And they're the dog owners?
No. The tenant are the dog owners.
Okay. But they're not identified. Did they receive notice?
Yes, as for the notice of violation and notice of hearing on the property of 902 Roberts.
Okay. Beg your pardon? Yeah. Hang on just a second. Okay, I'm looking at the notice of hearing, and it's sent to Victor and Henry Volusia, the property owners.
Certified mail, yeah.
Got it, which is the way it's supposed to be. But they're not, those folks don't own the animals.
No.
Okay. But those folks that own the animals are here.
Yes.
Okay, let's hear from them. And folks, I do need you to give me your name since I don't know who you are.
I'm Brandy Sidnor.
Ralph Hardy.
Okay. Just help me understand. You live here
Yes.
at this. You're the tenants?
Yeah.
Okay, perfect, thanks. What do y'all want me to hear?
We've been dealing with this for quite some time now, and we've actually, once we got these 5 different compliance notices and whatnot, we've started immediately getting in compliance with the code, okay? We've also came here several times. We spoke with Ron Paradise. We spoke with Mr. Lovett just recently a few days ago about all of this. We've told them that we've already been in compliance with everything that they have asked for.
Yep.
We have scheduled the dogs to be taken care of and everything like that.
I'm sorry. I'm trying to, I didn't understand your last statement, so if you could just.
Yeah, sure.
So you said you have what you have what dogs?
We have the 2 pits, the 2 dogs that are in question right now.
Okay, those are the 2 dogs that we're
Yes.
dealing with tonight?
Yes.
Okay.
Yeah, so we have scheduled them to have been neutered and sprayed and whatnot, whatever, which is May 31st, which is coming up. The other one is supposed to be on July 14th. Okay.
Okay, let me stop you.
Yep.
I'm sorry to be interrupting, but it's just, I'm just trying to understand what's going on.
Mm-hmm.
So, from the city standpoint,
Yep.
they're saying this case is just about 2 dogs,
Yes.
right?
Yes.
Okay, so you just mentioned a 3rd dog.
No, 2
The
dogs.
2 dogs.
I misunderstood then, I apologize. I thought I heard you say that there was an appointment on May 31st for the 2 dogs.
For the 1 dog.
Oh, for the 1 dog,
And
okay.
then
Stormy,
with the-
which they got information about, and July 14th is when Onyx goes,
Okay, okay.
Okay.
which they also got information about,
Okay.
too.
Okay.
So all of this is based off of, and this is going back and forth between several neighbors that live on Roberts Boulevard and everything like that. I have been more than cordial. We're trying to get everything resolved, keep everybody in peace, but this has gone beyond, just far enough. I've spoken to Nelson, I've spoken to some of your supervisors and everybody like that, and at this point, I feel like this is harassment at this point. I have submitted documents on top of documents on top of documents to the city, and if you guys say you keep your records like you say you do, you put them in your system, why do we keep getting calls and notified to say we're not in compliance, we're not in compliance? I don't understand that.
Okay, so the city,
We are the resident of land of Robert Boulevard.
okay, well,
This is on time.
okay, hang on a second, folks. Okay, hear me out. All I'm trying to do is find out, number one, whether there's a violation. I'm not interested in neighborhood disputes.
I agree
I'm not
100%.
interested in people getting upset or anything. I'm going to try to do what's right and what's fair, but I want everyone to understand that we're only here tonight on a pretty straightforward issue. And that issue is about 2 dogs that need to get fixed.
Yep.
They're getting fixed.
I get it. I get it. So help me help you, as they say in that stupid old movie. So I'm just trying to make sure that we're all on the same page, get the code in compliance. That's it.
I agree.
And I hear you're here and you're trying to comply. I get that. And that makes it easier for me. So what I'm trying to do is find out what's a reasonable time frame.
A reasonable time frame for us is the 60 days.
Okay, so
But July.
60 days from today.
say 60 days from today would be, May, June, so that would take us to the end of July. Or, approximately.
Yes.
What did the city ask for? What did you want?
We asked for 30 days.
30 days. Okay. Okay, so let me understand. If the appointments are kept, one of the 2 dogs is going to get fixed or spayed by the end of this month.
Stormy.
Okay. So the second appointment was July
14th.
14.
14th. Okay. So that would, if the gentleman's asked for, the folks have asked for 60 days. Okay. Help me understand here, because you've heard my earlier little speeches about what I'm looking for. Is there a safety issue? Is there a problem with that? And there's apparently some folks here that want to testify, but again, if they do, that's fine, but we're only talking about spaying and neutering. That's all we're talking about today, period. So is there a reason from the city standpoint that this has to be done in 30 days as opposed to the dates that these folks have said that they've got appointments?
No, there is no specific reason other than the time.
Okay, and that's fine. That's what I figured I'd hear. Okay, so folks, I'm inclined to give you the 60 days, okay, because it sounds like we're all trying to get to the same place. And with that said, does the city have any witnesses? Because there's some folks back there that are itching to come forward and say something. But I'm going to say right out of the gate, all I really need to know is about the spay and the neuter. I don't need to know about dogs running free. I don't need to know about anything like that. That's a totally different issue. This is not a dangerous dog case. This is just about spaying and neutering.
Yeah, just for that.
Okay, all right. Because this is not a public meeting. This is a public hearing. Okay? Okay, so based upon that, I'm going to find that you're not in compliance now.
Yeah.
That's pretty straightforward. I'll give you 60 days.
Yeah,
Okay.
I just lost my other dog last month. She got ran over. And
Sorry.
that was $300 out the pocket.
I'm sorry, ma'am, but again, I'm just trying to get to
understand.
state of the issue.
Yeah.
Okay, 60 days or a fine of $50 per day. Okay, so just keep the appointments and we're good,
Right.
right?
Already paid for it. They're cash.
Yes.
Okay,
Thank you.
all right, thanks a lot, folks. I appreciate you being here today.
No problem.
Okay. Okay, next case is DEL 22142, Howland.
We're done. And you know what? We're done.
Sir,
because-
we are done, so I'm going to ask you to leave. If you don't,
Yeah, we are leaving.
Okay,
because
thank
There's
you.
no reason for us to say they just left. And they've been crabbing. Their dogs
Okay,
been crabbing
sir,
all over our neighborhood.
we're done.
For 6 months. And you know what? You guys did nothing.
Okay,
Why
folks,
are we here for nothing?
I'll tell you what, I need you to leave, or, we'll take some other option.
Your Honor, do you mind if I testify?
No, we're done. Okay, the next case is DEL 22142. This involves property 2802 Howland Boulevard. Permit issue.
My name is Marion Laracy. I'm employed with the City of Deltona as Code Compliance Officer. This case is in reference to DEL 22-142, City of Deltona versus Cynthia Blomquist Insurance Agency, Inc. Property address is 2802 Howland Boulevard. Parcel ID number is 813-039-090-130. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Statutory requirements for this notification of this hearing have been met. Notice of hearing, code violation were sent certified mail to the property owner at the address listed with property appraisers. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a case that was given to me by the fire inspector. There was a report added in Exhibit B. Basically, the generator that was added to the property in 2004 was never permitted. And it was the electrical and mechanical permit that's required. City would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until the property is in compliance.
So it's still in violation,
Yes, sir.
just needs a permit.
Yes, sir.
30 days, or what was the fine the city's requesting?
$50 a day.
You spoken with the property owner?
Yes.
What did, I mean, they're here, so I'll hear from them, but what did they say?
She did state that she did admit that the generator was added to the property in 2004 for the hurricanes because it was happened at the last minute.
So it's been there a while?
Yeah.
Okay, quite a while.
Yes.
Okay, just needs a permit.
Yes, sir.
Okay, thank you. Yes, ma'am, you've been very patient. Tell me first identify yourself and tell me what you want to hear.
Good evening. My name's Cynthia Blomquist. I have a loud voice. I'm at 2802 Howland Boulevard in Deltona. I've been a State Farm agent at that location for 30 years. In 2018, as the young lady said, we had 4 hurricanes back to back. I hired Mike's Air Conditioning out of DeLeon Springs, Florida. He had done my son's home was under construction. He put his in. I'm sure it was permitted. His house was under construction. My son called me, said, "Mom, you need a generator during these storms." Mike came in, he gave me a proposal. I assumed that because he was a professional that he would have pulled a permit. So he put it in and I paid him. Every year since 2004, the fire department has inspected that generator every year. They inspected the electrical, they inspected the connections. One year I had to make an upgrade to one of my breakers. And here we are 18 years later, and I find out I didn't have a permit. It would be very easy to go pull a permit, except for the fact that now the codes have changed, and according to my new company that I'm working on getting the permit, I am no longer in compliance with the setback. So now the permit, the air conditioner has to be, the generator has to be totally removed and relocated. The problem is the casing is so rusted that I'm going to have to actually replace it, which requires that I get a site plan, quotes. I was notified of this in February, so I have not been 8 months. So I'm asking for a continuation to rectify this 18-year-old unpermitted generator, which has served me so well through 15 hurricanes since we put it in.
You're asking for a continuation. I'm not sure what you mean.
I have to replace it, or?
You're asking for more than 30 days.
Yes, because plus I have it inspected every year by Doc Watts Generator Service. I paid my renewal to them on February 25th. They could not get out to inspect it until April the 8th. I don't know if you've tried to hire anybody to do anything lately around here, but it takes forever. So it's not something that I can get done in 30 days. If I decide to do it at all, I may decide just to disconnect the thing.
Okay. Let me ask a couple questions, and I'm not sure who can answer these, but I'm just trying to understand the situation a little bit better. Is there anyone at the city that knows whether that generator is indeed sitting in a setback?
I don't know for sure. I think she's referring to the distance between HVAC unit and the gen set. Just looking at the picture, I don't think that it would encroach upon any yard setbacks as required by zoning.
It just doesn't sound right, but
yeah.
Maybe, who told you about that?
Doc Watts, I actually have a note from them an email.
Does it mention the setback issue?
He does.
Can you? If you let me look at it, I got to keep it. So.
Well, I can print it out again. It's an email.
Okay, cool. You understand what I'm doing? I'm just trying to understand the situation a little better.
That's from Jacob, the generator
while we're waiting on that,
specialist.
let me ask the city representatives, is the city aware of any, thank you, sir, any part of the building code that would allow this generator to continue to exist without a permit because of time or because of grandfathering or anything like that?
No, sir.
Does the city know whether indeed any representative has gone out and inspected, a city representative has gone out and inspected it? I thought I heard the nice young lady say that the fire department came out or something like that.
Yes, but they did send, the fire department reported me to compliance, and so then the compliance officer came out and said, got my story of what had happened and said she'd get back to me, and then the next phone call I got was I was not in compliance and I had to file.
Because of the permit?
Right.
Okay, let me read this now, okay? Just give me a second. Yeah, this is weird. It just, and this is for everybody. It says, based upon the pictures from previous maintenance, it appears that the generator would not pass any inspections due to not meeting setback requirements and would need to be relocated altogether.
They've asked me for an updated site plan, and they'll come out and do measurements. I don't even know what the requirements are.
First, let me say, reading that, given my history, that's not definitive, because it says it would appear. That's number one. I'm just trying to go to understand what kind of time frame is fair for everybody involved here. It's been there for a long time. It doesn't identify specifically what kind of setback we're talking about. You've heard the representative from the city, and so no one knows if it's really a setback issue from the lot line, because that's problematic.
I'm sure it couldn't be. It's at least 35, 40 feet from the road. It may be the AC unit, as you stated, because the AC unit is probably only about 8 to 10 feet away.
Yeah, and even that, like I said, I can't really speak to that, but I think there's going to be a site plan event that's going to be based on a survey, and I think that'll definitively ferret that out.
So what are we looking at from let's say that best case scenario, in other words, best case scenario, this young lady comes in tomorrow. She brings in her survey, she brings in everything else. And what's how long would it take to get the permit under the best case scenario?
I think if you had an electrical contractor come in and pull the permit for it, and the permit was filled out, it could be done relatively, the 30-day time frame is doable.
I have an electrical contractor.
Okay.
I mean, I've contacted several, but I did have one gentleman who said he would take it on
So that's
for me.
best case scenario. So the 30 days under that situation would be reasonable. That's best case scenario. So now let's talk about what are the options for compliance for this property if there is a setback issue. And by that, I'm not saying necessarily a setback from the road or the side lot, but a setback as far as it sounds like it may be too close to some sort of other electrical system. What would be the options at that point? Like, can you have a variance? Would the permit be rejected? And she'd have to relocate it? Okay, let's look at that photo. Is that it?
Yeah, from a building code standpoint, it would require a relocation to comply with those distance requirements of either, the mechanicals that need to be separated. This is, again, I'm not speaking, there isn't a variance or anything like that. This appears to not be a setback issue.
Okay, but we don't know.
We don't, no, sir.
Okay. All right, so let's just, what do you think? I mean, the city's asking for 30 days. It seems like it's a little more complicated than that.
And hurricane season starts June 1.
Well, I get that, but I mean, I'm sure let me ask this question. Let's assume, I mean, a permit, this is why you get permits, so that the city can come out and inspect it to make sure you don't have a fire issue, an electrical issue. They're inspecting the installation to make sure everything's cool. They're also looking to see if there's some sort of reason why it shouldn't be here in this location, which is an issue in this case. So let me ask again. Let's say that this thing's too close to the AC. What's the problem with that? Help me understand, why does the code say this can't be too close to the AC? The practical reason.
There may be questions about heat generation, exhaust, I don't know.
Ma'am, is this close to an AC unit? I can't see from that photo.
If you come out that door.
Yep.
And you come out probably 12 feet and go 6 feet over, there is an AC unit surrounded by shrubs so that it looks nice.
Okay. Does anyone in the city see this? If let's say I was going to give this property 90 days, is that creating a dangerous situation? Based on what we know tonight?
Yeah, based on what we know tonight, I mean, I think that 90 days is doable. I mean, it's been this way for a long time.
Yeah, I got to factor that in.
Yeah, I mean, and it seems to me that if it's all right, with the officer, I think it's worth contemplating.
Yes, sir, it's okay.
Okay. Ma'am, I'm going to give you 90 days. It just seems like there's some things that need to be sorted out, and from what I can tell, 90 days is a reasonable period of time for you to come in, find out what's actually, whether you can get this permit easily or whether it's going to require a little bit more time. Okay?
I appreciate that.
Okay, so I'm going to make, or a fine of $50 per day, but I'm pretty sure we're not going to have to worry about that. Okay.
If I may interject, Your Honor, I think it would be really helpful to have your electrical contractor interface with the building official, Mr. Carl Lynch.
Okay.
Carl Lynch.
Yeah, and he does a lot of the electrical inspections for the city.
Thank you so much. Have a good evening.
Okay, thank you, ma'am. Okay, the next case is DEL 22157. This is a dangerous dog hearing. Property is 1217 Winterville Street in Deltona, and it's Officer Lopez. The property owners are identified as, okay, I hope I get this right, Taylor Ralph Dennis, Taylor Betty Lou, or Betty Lou Taylor, I apologize, I'm just reading off there, and Jessica Reynolds. Okay, Officer Lopez.
Good evening, sir. My name is Nicholas Lopez. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-157. The City of Deltona versus Taylor Ralph Dennis, Taylor Betty Lou, and Jessica Reynolds. The property address is 1217 Winterville Street. The parcel ID number is 813-071-350-140. This is a violation of City of Deltona Ordinance, Section 14-166, letter B. Any dog that is the subject of a dangerous dog investigation shall be immediately impounded by the Animal Control Authority pending the outcome of the investigation and resolution of any hearings related to the dangerous dog classification. Corrective action for said violation is to comply with the statutes and ordinances pertaining to dangerous dogs. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records, as well as the animal owner. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. Dangerous dog means any dog that, according to the records of appropriate authority, 1, has aggressively bitten, attacked, or endangered, or has inflicted severe injury on a human being on public or private property. 2, has killed a domestic animal, or more than once, severely injured a domestic animal while off the owner's property. 3, has been used primarily or in the part for the purpose of dogfighting, or is a dog trained for dogfighting. Or 4, has when unprovoked chased or approached a person upon the streets, sidewalks, or any public grounds in a menacing fashion or apparent attitude of attack, provided that such actions are attested to in a sworn statement by one or more persons and dutifully investigated by the appropriate authority. On April 28, 2022, I was dispatched to 2660 Vaughn Court in reference to a dog attack. Upon arrival, contact was made with the victim, identified as Miles Mims. Mims stated that around 0830 hours, while walking down the 1200 block of Winterville Street, him and his golden lab, Buddy, were bitten by a gray cane corso that was running at large. Miles advised that there were 2 separate interactions within a 5 to 10 minute time frame with the corso. On the first interaction, the corso approached Miles and Buddy in order to inspect the 2 of them, which led to the corso biting Buddy. Miles then removed the corso, holding the animal until the owner became aware of the situation and came to retrieve the corso in order to return home. Miles advised that on the second interaction, shortly after the first, the corso reappeared to begin sprinting towards Miles and Buddy in a menacing fashion from the area of 1217 Winterville Street, prompting Miles to tackle the corso in order to protect Buddy from being harmed. This resulted in Miles being bitten in the face by the corso. Miles informed me that there was blood splatter on the ground near the 1200 block of Winterville Street where the incident occurred. Miles also advised that the owner of the cane corso resided at 1217 Winterville Street. It must be noted that while speaking to Miles, there were notable puncture wounds on both his left cheek and right hand area on his knuckle, but he also suffered puncture wounds on his left shoulder area. Upon investigation of the scene where the incident was reported to have taken place, blood splatter was found on the sidewalk, indicating that a violent altercation ensued. Photographs were taken of the nearby area and the sidewalk where the blood splatter was located. On April 28, 2022, contact was made with the owner of the cane corso, identified as Jessica Reynolds. Reynolds stated that on the first interaction, she did allow the corso to be out in the front yard in order to use the restroom, and that she did retrieve the animal from Miles following the first altercation where Buddy had been bitten. On the second interaction, shortly after the first, Reynolds advised that she waited until Miles and Buddy left her line of sight to release the corso, which enabled the animal to be at large again. On April 29, 2022, Michelle Mims, sister of Miles, advised via email that on the date of the incident, she had taken Buddy to the Oviedo Veterinary Care and Emergency Center for treatment since Buddy would not stop bleeding from his left shoulder area. Based on the facts of the animal owner allowing the corso to run at large, which resulted in injuries being sustained by both Miles Mims and Buddy, Reynolds was issued a citation for allowing the animal to be at large. A determination has been made that there is sufficient evidence under Florida state statute and city ordinance to classify and declare the animal as dangerous.
Let me interrupt.
Yes, sir.
Where, if you know, where the, you're calling interactions,
Yes, sir.
do they occur at the same exact location, or were there 2 different locations?
They occurred around the same location.
And that location?
That would be the sidewalk area.
Sidewalk, okay.
Yes, sir.
All right, it wasn't on private property, it was on a sidewalk?
No, sir.
Okay, please continue.
That would be the end of the narrative.
Okay. Anything further from the city? Do you have a witness or anyone else that you wish to bring forward to testify?
Yes, sir. Miles Mims, the victim of the incident, and Michelle Mims, the sister of Miles, are present today, and they could speak on the incident.
Okay. If you please come forward if you'd like to speak. Right over there. And if you could just identify yourselves, please. Let me know what you want me to hear.
My name is Miles Mims.
My name is Michelle Mims, and we reside at 2660 Vaughn Court.
Okay. And your dog is the one that was attacked,
Yes.
or allegedly attacked? The golden?
Yes.
Okay. What do you need me to hear?
Just confirming his things, and we just want to make sure that the dog is deemed dangerous. Just because, if it wasn't me, or it would have been a smaller dog, somebody or something could have died easily.
Okay, let me, because the facts are so crucial in all these cases. So where were you, tell me where you were when the first confrontation occurred. Were you in front of your house? Were you in front of?
In front of their house, so across the street on the sidewalk.
You were across, hang on, ma'am, okay? Everybody's going to get their chance. You're saying you were across the street on the sidewalk?
Right.
Okay, so tell me, did you see the dog coming?
I did.
Was it barking?
It was just walking fast.
It was walking across?
So I thought it was just going to go smell my dog.
Okay.
So
And then what
I
happened?
would let it do that. But then he got a little bit close to my dog and started nipping at him. And so I just held the dog down because I didn't want him to do that.
So he says nipping at him. Was it, because I own a dog, always had a dog.
Just
my
a
dog.
bite movement, and then it ended up being a lot worse than that.
Okay, but hang on, you just jumped ahead. So he comes up, he's smelling, and then he's doing the biting. Would you classify that he was kind of trying to play?
No.
Okay.
Like
So-
really just checking him out.
Pardon me?
Just trying to check him out.
Okay, and then you said it got worse. I mean, in the first confrontation, it got worse?
Right, so it went from him checking him out to just biting him.
Okay, is that the bite that we've seen in the photographs?
Right.
That was the first confrontation?
Right.
Okay, so when this dog bit yours, then what did you do?
I got on top of the dog because he kept...
Not your dog,
the cane corso.
The cane corso.
Because it kept trying to be on top of my dog to try to be aggressive with it.
Right.
And so I stayed on top of the cane corso until the owner assured me that she had the dog, her dog, the cane corso.
Okay, so hang on. How long are we talking about? Where was it? Like 30 seconds? Is a minute? 2 minutes?
Could have been a minute or two, that interaction.
Okay, so did the dog's owner come out over to you?
Right, after I had the dog.
Okay, and what happened then?
I just wanted to get assurance that she had the dog.
So she took the dog away?
Right.
Okay, then what did you do?
Went on with my walk. We proceeded down the sidewalk for maybe 50 feet. It felt like, 30 seconds, a minute later. And then I hear Hogan or Logan being yelled.
Okay.
So I turn around and I just see the dog running at us.
Okay.
The dog seemed to want
You're
to go
still on the sidewalk across the street?
a little bit farther down now because we've walked.
But you're on a sidewalk, and the sidewalk is across the street from the property where the dog resides?
Correct.
Okay.
So we're walking down, and I have to drop the leash because the first interaction I obviously couldn't.
The leash for your
control both
dog,
the dogs.
obviously.
Right. I couldn't control both dogs the first time, so I assumed it would be safer for me to just, and the dog, to just drop the leash and deal with the cane corso.
Was there a leash on the cane corso?
No, never.
Okay. All right. Then what happened?
I held the dog down while my dog continued to walk away, where I had the owner go get my dog because I didn't want my dog to get hit or something.
So there's some photos, like there's one right there. Was that a bite?
I believe that was from pavement scrapping.
Okay.
When I hit the pavement with the dog.
But did this dog bite you at all?
Right here. on my
Okay.
face, yes, sir.
Okay. Did you have to go to the doctor for that?
Maybe, but I didn't.
But I'm just asking you whether you did or you didn't.
No, I did not.
Okay. All right. So let's talk about your dog. Your dog did have to go to the vet.
And the animal hospital today.
He
Yes,
had surgery this morning, yes.
I'm sorry, what?
He had surgery this morning, yes.
Okay, tell me exactly what that was.
So he was bitten, and unfortunately, some of the puncture wounds were large, so they weren't so easy to heal. They were given staples, but unfortunately, they got infected. That one of the puncture wounds got infected. So now we're giving him a round of antibiotics, and he's got a hose extension out of him to try to deal with the fluid.
Okay. Okay. All right. Anything more you want me to hear?
I would like to add that I filed an affidavit on this dog on January 20th, 2022.
I have seen it, and I've reviewed it. And I've read yours as well, sir.
Okay.
City have anything further?
No, sir. Actually, the sister of Miles Mims, she has photographs of the animal surgeries, if you'd like to see them.
It's up to you whether you want me to see them or not.
Yes, I would like you to see them.
Okay,
If you
then
don't mind showing them.
if you give them to me, they're part of the record. You understand? They're on the phone?
It's on her phone. Would she still be able to show it to you that way?
Yeah, it's not, I can't make it part of the record. So
Can I email them to somebody?
you know what, let's just continue on with the hearing, and we'll see where we are at that point in time. Does the city have anything further?
No, sir.
Okay. I'm assuming that since this is an appeal, that the dog's owner is here. Thank you. Have a seat. Dog's owner is here and wants me to hear you. Come forward, ma'am. And again, if you could identify yourself and your address, please.
Jessica Reynolds, 1217 Winterville Street.
Yes, ma'am.
Alan Reynolds, 1217 Winterville Street.
Okay, so that's a new name. So do you live in the property as well?
Yes,
Okay. Does the dog belong to one or both of you, or?
both of us.
Okay, fair enough. Okay, go ahead, ma'am.
So what do I just start from the beginning?
Tell me what you want me to hear.
Okay, so that morning, he was right there in the front yard. I was probably maybe from here to about where that guy is. So I was right there with him. They started walking. He actually didn't run towards them. He started walking over to them just to kind of investigate. I hear him call him, so I stopped. I ran over there. He, at that time,
Wait a
had...
minute, you said you heard him call him.
I mean, I was calling Hogan,
Okay.
saw him that, to kind of go over to the dog. All he did was investigate. He didn't run at them in an aggressive behavior whatsoever. Walked over just to investigate the dog, and then I'm not sure if his dog got spooked or maybe nipped at him to make Hogan go back at that. But then, it literally lasted about 10 seconds. At that time, if he was aggressive, he could have easily bitten the guy if he wanted to, because he was, trying to separate the two dogs. So he had every right at that time to bite him if he wanted to. He didn't. He was able to get him under control and separate Hogan from his dog. Like I said, within 2 seconds, I was over there. I had him. He's like, "Do you have him?" I'm like, "Yes, I do." Waited there. Walked all the way down to that very next stop sign.
When you say not you, but the other gentleman that was just
Yes.
testifying.
He says, "Do you have your dog?" I'm like, "Yes." So I have my whole body around him. We're waiting. I watch him every step. He walks.
So you didn't go back to your home. You were just still at the.
I stayed there holding him.
Okay,
to make sure that he was gonna. So he walks down to the very next stop sign. Goes to that, clears the stop sign, goes on to the next road.
Okay.
Out of sight, didn't see anything, was gone. So I even waited an extra about 10 to 15 seconds just to make sure he was cleared. I go to walk Hogan, because at that time I have no leash, nobody's outside. House was I going to get him back to the house? I couldn't pick him up. I had to escort him back over to my yard, which is just right across the street. As Hogan goes back to start me walking him across, the owner comes back around and standing there with the dog. So then at that time, I couldn't hold Hogan. He goes after, he starts, not aggressively again, just starts going, trotting down there. At that time, that's when I saw him. He was like this, and he literally attacked him and threw him to the ground. And when he did, I saw him roll over Hogan, where at that time he got the scratch from the sidewalk on his knuckle, and literally bulldozed him over, and that's where they landed in the grass. And I think that mark on his face would be just a tooth mark hitting his face, as his face was close to Hogan's, as he stated. What's the word he used? Tackled him to the ground.
So we're not basically disputing that there was a violation, because obviously he was unleashed in the front yard. We're just disputing the dangerous dog classification due to what we had read as to what constitutes a dangerous dog due to the severe injury or aggressively biting a human being. It obviously was not an aggressive bite, if a bite at all. It was more of a defensive nip, or even possibly, like she said, just to where he came in contact with his face with one of his canine teeth or something.
And with the picture, he has facial hair on his face. You cannot tell for sure 100% that that's a bite mark. You see that my dog, that if he wanted to bite him, it would have been more than that if he wanted to bite him.
Okay.
And then back to the state, where she said she filed January 20th, we were never notified, nothing, zero. So we have no idea on January 20th that she filed a an animal control report on us. Nothing.
Well, just so you know, I'm relying upon what I'm
Okay,
seeing and
okay.
hearing today.
Okay.
You know, I said that at the beginning,
Yeah, I'm
I'm
sorry.
saying it again today.
Okay.
I mean, that's why it's important for you all to be here. It's important for them to be here, because those are sworn statements, and that can be helpful, but it's a lot better when you all are here, you're here, and
we
so
also have the letters
I
from
get to
the
ask questions. Yeah, I can't ask questions of an affidavit.
Yeah, and we have letters from his vet and then 2 other people. We've had him socialized from 8 weeks old as a puppy. People, kids, small dogs, big dogs. We have cats, everything, and there's never, ever, ever been an issue. So I think, like, when he went over to investigate him, maybe, because like you said, he didn't walk slow, he didn't run. When he went over to investigate his dog maybe got scared or something, and not really sure. I wasn't there that second. But we do have we have statements from witnesses and stuff that have interacted with Hogan and his vet.
Okay. Anything else you need me to know, ma'am? Sir?
Yeah, main reason for our appeal was just due to the contradictory statements and stuff as far as him being bit multiple times and things like that, and with him being classified as a dangerous dog, didn't seem like the classifications from what I read, from what I was provided, it says serious injury is...
Cosmetic surgery.
Yeah, well, a lot worse, obviously, than what took place
And he didn't
there.
go to the doctor, so if it was serious,
So that's our defense as far as not getting him
I understand.
classified as a dangerous.
Yeah, it's no fun to have your dog deemed dangerous.
Yeah.
I understand completely. This is a serious matter today, for all parties concerned.
And
For all parties concerned.
I apologize deeply. I was in tears in front of him.
You know what?
I'm the biggest.
I
know.
get that. I get that.
So we also went and paid the medical bills for, my husband went down, apologized, and gave $400 to pay for the whatever at that time that we even knew what was going on. So we paid everything that they needed to have paid for.
Yeah, I'm not sensing here that anybody, any of the human beings here did anything wrong, and you all have tried to do the right thing.
I mean, I did. I
And I
apologize
get
for
that.
not having him leave.
So this really isn't about that. This isn't about blame. This isn't about punishment. This isn't about payback. Let me tell you what this case is about. This is about me trying to listen to the facts and then apply the law to those facts. So let me tell you the law. So this is what, and you've read it, but I'm going to tell you what the law is. And this is, you can have a seat.
Oh, we can have a seat?
Okay, thank you for being.
Do you want the letters, honey?
What's that?
The letters?
Probably not going to matter, I guess, obviously, if he doesn't want
The letters from the witnesses? I mean, not the witnesses, not the witnesses,
No, I'm fine. I think I understand. I need to know what happened. Okay? And I'm pretty sure I understand that. So here's the part of the Deltona Code that applies. And this is in the part of the record. This is in section 14-166, folks, subsection B. And it's just kind of more of an identification of what I have to make a determination. It says a dog is deemed dangerous if it has one of the following: aggressively bitten, attacked, or endangered, or has inflicted severe injury, and that's defined right here as any physical injury that results in broken bones, we don't have that, multiple bites, maybe, or disfiguring lacerations requiring sutures or reconstructive surgery on any human being, that clearly didn't happen, or domestic animal, lawfully on public or private property. And it's that last clause. Let me tell you why I read the whole definition, because all of that has to apply in order for me to get to the point where I can find the dog to be dangerous. So you heard me ask the questions: where did it happen? Where were you? All that kind of stuff. So where this happened was on public property. It was in the sidewalk, and it was across the street. So the other thing that I've heard is that, in looking at this code, it says a dangerous dog that has endangered or inflicted injury, severe injury. What is a severe injury? It's a bite that can cause disfiguring lacerations requiring sutures, which happened, or reconstructive surgery. This is important, on any human being or domestic animal. Now, it's important for everyone to understand that what the law that I have to follow in making this determination is city code. Because, and it's important to understand this, the city code and the definition of a dangerous dog is different than the Florida statutes. Florida statutes, if that were to apply, this case might come out differently. But under the code of the city of Deltona, which is the charging code for tonight, it's my conclusion and it's my determination that the facts show that what happened on that day meets the standard for me to deem this, to uphold the determination that this dog is dangerous. And I'm going to make that determination. Why I'm going to make that? Because this dog, your dog, did attack or endanger, the other dog, and inflicted injury, severe injury, as defined by a disfiguring laceration requiring sutures or reconstructive surgery, not on a human being, but on a domestic animal lawfully on public or private property. Based upon that definition and the facts as I have received them this evening, I'm going to uphold the initial determination and deny the appeal and conclude that this dog is under the code is a dangerous dog. So, no, we're done.
We're not talking to you, okay?
There was no suture on the dog when we went there. And this is the first we've ever heard of any kind of staples or anything like that whatsoever. Is that still not the working factor?
Okay, the next case or cases deal with 1870 Providence, and it's DEL 22051, 052, and 053.
Go ahead, do something.
Thanks.
These are all Massey cases, 051, 052, and 053. This is Officer Muse.
Okay.
Hang on a second. Was there a law enforcement officer?
Yeah, he was right here. He's out back.
He needs to go there.
He did. He is there.
Because, I mean, I'm not sure what's happening right now, but it ain't going to be
Like
pretty.
I said, he walked out.
Okay, good.
The front of the door here.
Thank you. Okay. All right, 2205, 052, and 053, all dealing with, these are all Massey cases and all deal with 1870 Providence Boulevard.
Okay, Mr. Richmond. My name's Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. My credentials are on file with the city. This is a case number, if I may read all these, since they're all the same violation, all the same basic location, just different parcels, same owners.
Okay.
Okay. This is a case, DEL 22-051, 052, and 053. This is a Massey case. Basically, what's going on here is the property is the same as it was. We are going to go ahead and ask for 30 days to get this done. They have come in and applied for a permit. Trying to get you a picture up here.
So what I'm hearing the city say is that there's been some efforts made to bring the property into compliance, and based upon that, the city's not asking for a fine to be imposed.
Not at this time.
But for there to be an additional 30 days for compliance.
Yes.
From today.
Yes, sir.
Okay.
And
then the fine would accrue if there's not compliance within 30 days.
At this time, yes.
Okay. Anything further from the city?
That'd be it.
Okay. Is there someone here representing the property? If you could give me your name, sir, when you get there.
My name is Gabriel Fernandez.
I'm sorry, sir, I couldn't hear you.
Gabriel Fernandez?
Okay. And you're here on behalf of Foray Investments, LLC?
Yes.
Okay. Did you hear the city, what the city is?
Yes.
What's your position on that?
Hopefully we can complete the job in 30 days.
Okay. So 30 days should be enough?
Probably, yes.
Okay. Well, I'm going to agree with, if the city's willing to give 30 days, I think that's fair because the deadline has already passed. So I appreciate you making efforts to comply. And what this means is there's no fine, zero fine, and there won't be a fine unless 30 days from today, the property's not brought into compliance.
Yes.
And then the fine that was set forth in the original order, fines plural, because there's 3 cases, will start running. And no one wants that. Do you understand what we're doing here tonight?
Yes.
Okay, and that's what my order is going to be on these 3 cases. No fine, an additional 30 days from today, or then the fines will begin to run.
Okay.
Okay? All right, thank you for being here, and thanks for cooperating and trying to bring the property in compliance. Okay.
Thank you.
Great.
Thank you, sir.
Okay, this is all one property? Yes. Okay, we got a bunch of cases, and it looks like they're all Massey's, and it all has to do with 1835 Twin Oak Street. And cases are 072, 076, 079, 080, 081, 082, 083, and 084. So we're going to start out with 072. Okay. 1835 Twin Oak Street. These are all Massey cases.
My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This will be a Massey case number DL 22-072, City of Deltona versus Thomas Coleman. Property address is 1835 Twin Oak. Parcel ID is 812-800-000-070. Statutory requirements for notification of this hearing have been met by the notice of hearing, notice of code violation sent certified mail to the property owner at the address listed with property appraisers. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on March 21st, 2022, that the property owner was given 14 days to comply. The property owner did not come into compliance within those 14 days and has been receiving a fine of $100 a day since April 5th, 2022. As of today, the property has accrued a total fine of $5,000 over 50 days. The city is requesting the fines continue at $100 per day.
So the property's still in violation?
Yes, sir.
Tell me how it's in violation.
There's a car parked on the property along with a trailer.
Okay, this is case 22072.
Yes.
Vehicles registered. So the violation is that the location where they're parked?
Oh, is this in-op vehicles? I apologize.
I'm sorry, what?
This is for in-op vehicles, is that?
Yeah, we're on 22072, correct?
I apologize.
So tell me why is this property still in violation?
Property is in violation because of the trailer on the property.
Hang on a second. Okay, this case involves a vehicle parked or stored on property that needs to be registered or assigned to the resident or their temporary guest.
That is correct.
Okay, so which vehicle violates that section?
Both vehicles. The car is not registered to that property. It's registered to the owner, just not that property. And the trailer is not registered.
Okay.
From what I can tell.
Okay. Okay, now I understand it. So you're saying that condition still exists on the property?
Yes, sir.
And has for 50 days beyond the deadline. and it was $100 per day in the prior order. Okay, is there someone here for the property? Please, sir, if you'd come up and give me your name and tell me what you want me to hear.
My name is Tom Coleman. It's very upsetting how inefficient the city is. That trailer's been gone since the beginning. That is not the trailer that is on the property today. The blue car I drive, that's the trailer that's been there for 2 days. Can you go back can you see their different trailers? Those are all gone. That's the car. That trailer was pulled out there this morning. It has a motor on it to go to the scrapyard.
Okay.
Okay.
Okay. So let me see if I understand what I'm hearing here. Is that there was a specific trailer and a specific vehicle that were the basis for this case in the beginning, correct?
There was multiple trailers.
Okay.
All gone.
Okay. So the blue car was the basis that you're saying
It was one of the vehicles.
Excuse me?
One of the vehicles.
There was multiple vehicles.
There's multiple trailers, and then the red car and the blue car.
Okay. So the gentleman says that all of the trailers that were the subject of this case before have been removed. Do you know whether that's true or not?
I mean, this was a picture taken today.
And that trailer wasn't there at the beginning. That was a trailer that I borrowed to remove the stuff, which I am doing, you know.
When did you remove all the other trailers?
Since the beginning, I put them on Craigslist and sold them, not in one day, but they were all removed before the deadline or put inside. This is crazy.
This trailer here is April 12th.
I'm sorry, say that again, ma'am?
This trailer here in the photo is April 12th.
As you can see, it's loaded with stuff to go to the dump. Yes, that was there, but it was there a very short period of time, and it is licensed.
All right, so we've got a factor dispute here about whether the trailers that were the subject of this case, whether they were removed by the deadline. Correct. So what's the date of the deadline in the prior order?
April 5th.
April 5th, okay. So is it the city's position that that trailer right there, which was on the property, according to that photograph on April 12th, was one of the trailers that was the subject of this case?
One of the trailers from the initial case, it's hard to tell because he had multiple trailers, and we were not allowed on the property at the time.
I've never denied him property access.
Okay,
sir.
that's not,
okay.
We're trying to stay focused on,
Yes.
Listen to my questions really carefully, because I'm not trying to hurt the city, I'm not trying to hurt you. I'm trying to determine whether there's been compliance with the prior order.
Yes, sir.
Simple as that. Okay, no one's good, no one's bad here. This is just about the facts, like those stupid movies, okay? So the city's position is that there's been a continuation of this violation after the deadline, and the deadline was April 5th. Is that correct, officer?
That is correct.
Okay.
That is not correct.
So I understand, I'm getting to you, hang on. So that trailer, was that one of the trailers that was the subject of this case? It's for you, sir.
I don't think so, but I'm not sure. That's a borrowed trailer. It's not there all the time. There were ones that were there all the time that have been removed. As you can see, it's loaded up with stuff outside my yard, ready to go to the dump.
Okay, are there any trailers on the property now?
Sir?
Do you have trailers on the property now?
Not on the property. I have this trailer loaded with other stuff that I loaded this last night to go to the metal recycling place.
Okay, but you didn't answer my question. Are you still keeping trailers on the property?
Right now, at this period, there's no trailers on that property.
Again, that's not my question. I know you're wanting to answer the question you want me to ask, but it's not the question I'm asking, sir. I'm asking you, are you still keeping trailers on your property? Are you using trailers on your property? Because it sounds like you haul stuff with trailers.
Just stuff that I have to remove to get rid of this insanity.
Okay.
It's not come and go new stuff. Okay.
So let's go back to the blue car. Let's
That's
look
my everyday driver parked on outside.
Okay. So why is that car in violation of the code?
It's not addressed to the property.
What is it addressed to?
Registered to the mailing address.
I drive to the property. I don't walk. The car is not there
It's
unless
parked there. Anytime that we've gone, it's always parked there.
So where should it be, according to the city?
Well, if he's claiming he doesn't live there, which is one of the cases that we have, it should be at his residence.
Well, it has to be there to remove that trailer. Unless I
The main
drag
part
it
was
physically.
that when we went over there, the trailers were still parked on the property after the fact of April 5th.
You have a picture?
Okay, here's what I'm going to do. Here's what I'm going to do. I'm going to say that there's no fine as of today. But if those trailers get back on their property,
There is only one trailer, and that is the only one.
shouldn't be any trailers on that property that aren't registered or licensed.
That is registered. Okay, sir, sorry.
I'm just telling you, this, if you know, you can play right on the edge, but it might come back to bite you. She's not going to bite you.
Oh, no,
I'm going to bite you.
Oh, and hard.
So I'm just giving you a heads up, because I don't want to bite you. But if I have to, if you make me, I will. So I'm going to say there's no fine. But, and this is what if there's trailers on this, again, it'll be a repeat violation.
Can you use a singular, because there will never be anything but one trailer on that property.
I'm saying there can't be any unlicensed or unregistered trailers on that property.
And never will be. Thank you.
Mr. Reichman, Richard Lovett. As your order on DEL 22079 on this same property, you gave him 24 hours to vacate that property.
On this
So he
case?
should not even be on the property as of today.
Well, that's not this case, though.
Yeah, but that's why.
Well, we're not on
I'm
that
saying
case.
No.
That's why.
More
they're all
insanity.
Different order. Is that a different order?
Yeah, it's a different order on 79, but that's why all that ties together.
Okay, that's fine, but we're on this case right now. And this case is for this code, says that you can't have unregistered, unlicensed vehicles on this property. And I'm reminding the gentleman that I've already found that you were in violation. So
I'm not arguing that point, sir.
So if this happens again, you're not going to get any notice. You're not going to get any breaks. There'll be a fine that'll start running immediately.
Sir, this is a registered trailer.
I'm just saying if there are unlicensed
right,
or unregistered
Yes, sir.
vehicles on that property.
If one falls out of the sky, I'm in violation. Yes, sir.
Wherever it falls from.
Thank you.
Okay, so let's talk about
But is it there now?
Okay, I want to stand about this blue car, because I'm still trying to figure out exactly how this is in violation.
Me too.
Is this a vacant lot?
Yes,
Oh, here.
technically, according to property appraisers, it's supposed to be a vacant lot.
So in a vacant lot, you're not supposed to have any vehicles there at all, or parked there permanently, or?
Park there, structures, correct.
Okay. All right. You said the property appraiser said it's a vacant lot. You've been out there.
Yes, sir.
Is it a vacant lot?
No, sir.
Okay. What's on it?
There's a structure on the building, on the property.
Okay.
There's since 1978.
Hang on. Okay, so just because the property appraiser says it's a vacant lot, does that control over the fact that when we go out there, we see that it's not a vacant lot? And I'm being argumentative, but I mean, it's important to this case. It's
Correct.
important to this case because this case only works if the vehicles are parked inappropriately in violation of the code on a vacant lot.
Mm-hmm.
How do you determine, for purposes of bringing forward this code case, that it's a vacant lot? I mean, you can look at the property appraisers, but they
Technically,
could
it's
be
supposed
wrong.
to be an unapproved lot. It was 2 lots when he had a house.
3 lots.
And then,
Sir, I'm going to ask you, okay, you got your chance, but she doesn't interrupt you. That rule works both ways.
he sold off the property that had the primary structure on it, continued to reside in this property here at 1835, in the workshop that's on there.
Okay, 1835 used to be part of a bigger parcel,
That is correct.
okay? And then it was divided,
Yes,
okay?
at some point.
So on 1835, the only thing that's on there, other than these vehicles and these trailers used to be, is a workshop,
There's a workshop, there's a dock, there's concrete, yes.
okay? So the property appraiser must have said, okay, because there's not a living structure on this property, then it's vacant.
I'm not sure what they would,
Mr. Wright,
it was just never changed to an approved property.
there's no permitted structures.
Okay, that's what I needed to hear. Okay, here's where we are. You got a lot because it's divided legally, and it doesn't have any permitted structures on it. Then, based upon Florida law, it's a vacant lot. And under the code, this is how it works. You know, it may not make sense, but this is what, you know, the law is an ask. So you got a lot. It was divided out. There's not a permitted structure on it, therefore it's a vacant lot. And a vacant lot here in Deltona, for better or for worse, you can't park a car on it because they don't want people parking cars on vacant lots. So what I'm going to find, so I'm doing you a favor, I'm going to find there's not going to be a fine. But from this point forward, if there's any trailers on there that are unlicensed or unregistered, or if there's any vehicles out there, correct?
Correct.
Then it's going to be a violation. So I'm going to find that there's not a violation at this time. There's no fine, but I'm giving you a heads up. This nice young lady or someone else on behalf of the city can go out there and see that blue car or any other unlicensed trailers, and they can tee it up for what's called a repeat violation. You follow me? And that'll be a fine from that point forward. So that's my ruling.
Can I have a question? Oh.
Yep, go ahead.
I own the property, I'm vacating all this stuff out of it. When I drive to the property to vacate the stuff, I drive my blue car. When I leave the vacated property, I take my car with me. That trailer is licensed. The property, I did not subdivide the property. It was subdivided. That's a complicated issue when I bought the place, or partial out. But anyway, thank you, sir. I move on.
Yeah. Okay, so that's the DEL 072. Let's go move on to 076. This is debris.
My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is a Massey case, number DEL 22-076. City of Deltona versus Thomas Coleman. Property address is 1835 Twin Oak. Parcel ID is 812-800-000-070. Statutory requirements for notification of this hearing have been met by the notice of hearing. Notice of code violation sent certified mail to the property owner at the address listed with property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on March 21st, 2022. The property owner was given 7 days to comply. The owner did not come into compliance within those 7 days and has been receiving a fine of $100 a day since March 29th, 2022. As of today, the property is still in violation and has accrued a total fine of $5,700 over 57 days. The city requests the fines continue at the $100 per day.
Mr. Coleman.
They're sneaky. I didn't see them take the pictures. There was a, can we go back one picture at a time, please? Thank you. I owned a piece of property. There was a fence there that I removed, a plastic fence so my dog could go back and forth. That blocked the opening. I saved all the pieces and put the fence back together. That piece is going on that trailer tomorrow. So they only come out and take pictures when something's there. That is a broken down fence. I have no, it's, you know, if we're nitpicking, yes. I mean, I wish they showed you pictures before and after. That's wood for the other fence. That's.
All right, so let me do this. Fair enough. So I'm going to ask, let's start at the beginning with the first picture. Let's just start there. I need to just stop the rotation. Start somewhere. And I'm going to ask you as to each picture, is it still there or not?
These were from today.
Sir, I'm going to tell you one more time.
Sir, shut me off.
Okay.
All of these pictures that are I'm showing right now are from today.
Okay. Let's go through them. because I need to see them again. Number one, the answer still there. Next slide. Okay, next slide.
That's it.
Okay, so I'm getting to you. Hang on. Is it better now than it was when we first met on this case?
It's almost the same. I do have pictures from before. Hasn't
Okay, sir.
very much improved.
Your turn. It's not nearly the same. These pictures are all of today. I would like the before pictures. But that'll be gone on that trailer to the recycle. Next picture, if it's okay with you.
Okay, let's go through the pictures again, if I could, officer.
One at a time?
Go ahead. Okay, let's go through the pictures. Okay, tell me about that one.
That I used to put across the doors to keep my dog in when I was there. So that I have no justification for. Except I did have it inside, so somehow I got pulled outside and then left there.
Next picture.
That's an overgrown, you can't see it from the pictures, but next to the entrance, there's 2 flower beds, and they are overgrown, not as much as they were, but the debris has been removed from them. If she had an original picture, oh, there's a sign, there's some debris still there.
Okay,
it's completely different now.
Next picture.
That's been there, that wasn't there originally. That fence I have to put up to keep my dog from running into the lake, and those other boards, so that has been there a while. I have no justification for that.
Next picture.
Terrible violations, I'll tell you, I don't know how I live there.
Next picture.
No justification. That's part of wood to replace on the fence. That I thought was gone. It needs to be recycled. Hazardous material, that car part I believe is gone. And that other stuff should be gone.
Next picture.
Same.
Next picture. Okay, same thing. Okay, I get it. Okay, here's what I'm going to do. The property's still not in compliance.
Yes, sir.
I mean, there's just no disputing that. And it should have been in compliance some time ago based upon my prior order. So I'm going to impose a fine. I'm not going to impose the amount, the total amount, because there has been some progress made.
A lot.
But I'm going to impose a fine. The fine's going to be an amount of $1,500. Now, that's bad enough. But the fine's going to continue to run at $100 per day. So it's $1,500. Tomorrow it'll be $1,600. Friday it's going to be $1,700. Because this order was entered a long time ago. And this case started a long time ago. Long time ago. So what I'm asking you to do, what I'm encouraging you to do, is that since you're contending that those aren't big deals, which I agree with, or at least not as bad as it was, it shouldn't be that difficult to go out there and get rid of those so that the fine won't be more than $1,500. Okay. Next case is DEL 22079. This is a case.
Can I ask one more thing?
Yeah.
If this was the only ball they gave me to juggle, this pile of poo, this would have been easily resolved. But as you see, all these things come on me.
I'm taking that into consideration.
Okay,
that's why I reduced the fine.
Okay.
Okay, 22079, unapproved residence.
My name is Mary Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is a Massey case, DEL 22-079. City of Deltona versus Thomas Coleman. Property address is 1835 Twin Oak. Parcel ID is 812-800-000-070. Statutory requirements for notification of the hearing have been met. Notice of hearing, notice code violation sent certified mail to the property owner at the address listed with property appraisers. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including the photographs, have been marked as exhibits and submitted to Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayal of what I observed the day they were taken. The ruling was on March 21st, 2022, that the property owner was given 1 1 day to comply. The owner did not come into compliance within that day and has been receiving a fine of $200 a day since March 22, 2022.
So what's the compliance here?
He needs to vacate the property.
So he's living in a place that's not permitted for someone to live in?
That is correct.
Okay. Is he out of the property now?
I have not received any indication that he has vacated. Any time that we've gone, he's always been there with his dog and his car.
Okay, so if I were to find that he is not coming into compliance, what would the fine be?
It was $200 a day as of March 22nd. As of today, the property has accrued a fine of $12,800 over 64 days.
All right. Mr. Coleman, you still living in there?
No, sir. I am vacating the property as you see these pictures. When I'm there, my car's there. It's crazy that they only have pictures when the car's there. They don't have any before pictures. And one reason not to let them on the property, if I didn't let her on the property, you wouldn't have all these pictures. So I'm trying to cooperate.
Okay.
And I may not understand the definition of vacate. I just thought vacate was not live there.
Fair enough. Let's define that. What is it that he needs to not be doing there?
Living in that.
Okay, so it's a
building.
workshop. That's the workshop.
I'm not sure exactly what it is. I know it's a structure, and he was...
It's not permitted for a residence, which means, getting his mail there, getting his electricity there, sleeping there, eating
had
there.
Electricity and water there.
Yeah. Are you eating there?
No, sir.
Are you sleeping there?
No, sir.
Where do you eat and sleep?
Oh, my son lives in Osteen. I have a neighbor, and my primary residence is down the street. But I have a pit bull, and things have changed, especially since COVID.
So tell me how you use this property. Normal day.
I use it to continue the insanity of trying to get it where I can get it out of my name, because I was told the first day they're going to take my building, so I'm cleaning it up, and this issue will come up later. So I'm just...
Yeah, but I'm not... Okay. Do you go there every day?
No.
The days that you go there, do you put in a full day?
Nah, I'm 71 years old now. This morning I had some people come from Tampa, typical day. They bought some stuff, brought a trailer, and they loaded it and left. So I was working there a couple hours, or they were working. They were just loading stuff up.
Fair enough. So, I've got to find that he's residing there in order to find him. So I'm asking the city, do you have evidence that he's sleeping there, that he's eating there, that he's spending all of his time there, that he's residing there? It's one thing to say he resides there. It's one thing to say he lives there. But those are conclusions. Those are just based on, you've got to back that up with the questions that I'm asking. So does the city have evidence that indeed he's sleeping there, that he's doing all the things that you do in a residence at that location?
At the original hearing, we did provide evidence in the case from VCSO stating that he was residing and living in this building.
Say that again now?
At the original case that we heard in March, we did provide the photos from VCSO stating that he was residing. There was evidence of sleeping arrangements, water, toilet,
right.
electricity.
Thank you. I remember that.
And he has yet to provide any proof that he is residing anywhere else to us.
Well, he's saying he lives down the street. Give me the address of where you say you live.
My primary address is 1710 Twin Oak Street.
That's not what I asked. I asked, where do you live? You said that's your primary address. Where do you live? Where do you sleep? Where do you reside?
Primary at my son's house in Osteen and a friend's house on Gainesville, not too far away.
So you're asking me to believe that, because it's confusing.
To me, too.
You've got your primary address down the street, but you don't live at your primary address. You live with...
I can live there. I can live there if I need to. It's just kids and things that's just, at my age and what I do, more convenient not to be there.
So you're saying every day you're not residing at this place?
Absolutely.
1835. You're living with your son or some friend?
Yes. Yes. And I go out of town a bit, and I'm not there every day on any level. That can't even be, not even sane. They come by, hypothetically, they come by every day and they take a picture. When my car's there, they save that picture. But anyway, go ahead. I don't live there. and we still didn't define vacate.
Do you have photos, or based upon your own, testimony, firsthand testimony, that you've seen him sleep there, that you've seen him prepare a meal there, those types of things?
I have never been inside the structure. The only pictures that I'm relying are from what we received from VCSO. And like I said, he hasn't proven to us otherwise.
I didn't know I needed to. That wasn't an issue.
Well, that's what we're dealing with tonight.
Can, Ms. Larsey, have you gone by there in the morning and at night?
Any hour, different hours of the days, any days.
And those
Multiple
times,
different
have you
days.
seen him there?
Yes.
Those times include when you start work at 7 o'clock in the morning
Yes.
and at 7 o'clock at night?
Yes.
Have you ever driven by there in the evenings, later?
I have, because we work a 7 to 7 shift, and we see the car out there.
Okay, but again, my question, same rule applies to everybody here. I mean, if you've been out there to see that it's 10 o'clock at night, it's 11 o'clock at night, it's midnight, and his car's there and the lights are off?
No, because I do not work those hours.
So what I'm hearing your side, sir, is that it's a vacant lot because it's not a structure that you're allowed to live in.
It was there before oh, yes, sir, that's correct.
That's irrelevant. So you're not supposed to be living out there.
I don't.
And you're saying that you're out there, and I tend to believe the city that you're out there a lot.
I have to
Don't
vacate.
argue with me. I'm just telling you. So you're out there a lot. And so there's a fine line between being out there a lot and living there. So when you're out there a lot, I mean, look at these photos. I mean, that doesn't look like just a workshop. That looks like somewhere.
That was taken how long ago? It looks nothing like that. Now, those are all gone. It's just, that's all gone. All those toolboxes are gone. That's good. Well, they're sneaky with their pictures. All that's gone. Okay. These are old pictures. These were not, well, okay, I can't say that.
All right.
Boy, you are sneaky.
I don't, that kind of commentary is not helpful.
I'm just trying to educate people, sir.
All right, I'm gonna find that I have received evidence to prove that you continue to violate.
Can I ask something?
You never keep talking when you win.
I'm not winning.
On this case, you just won.
Okay.
That's my advice to you. If you want to keep talking, maybe you'll convince me that I'm wrong and I should enter a fine for you.
Can I continue this to next week and bring in current pictures? Okay, just no is fine.
No, these cases are separate. I'm going to find that I'm not going to have a fine. There's no evidence of residency beyond the deadline. But I'm going to remind you that this next time, if you go out there and you're living there, and so this is for both, for the city and for you. If you're out there and you're spending all your time out there and you're eating out there and you're sleeping out there, and the city brings evidence of that, actual evidence of it, it's going to be a repeat violation, and the fine will start at $200 a day from that point forward. You won't get notice or anything like that. It'll just start running. Okay. That's DEL 22079. Next case is 22080. This has to do with a permit.
There's 4 cases that were a no permit. I was asking if we can read them in all together, since it was
So those cases would be, hang on a second,
080, 081, 083, and 084.
are the facts identical in all those cases?
Yes, sir.
Okay. Is that okay with you, sir?
Yes, sir.
Okay, great. Let's go ahead then. cut to the chase.
My name is Marion Laracy. I'm employed with the City of Deltona as Code Compliance Officer. This is a Massey case in reference to DEL 22-080, 081, 083, 084. City of Deltona versus Thomas Coleman. Property address is 1835 Twin Oak. Parcel ID is 812-800-000-070. Statutory requirements for notification of this hearing have been met by notice of hearing and notice code violation were sent certified mail to the property owner at the address listed with property appraiser's records, in addition to the notices posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on March 21st, 2022, that the property owner was given 60 days to comply. The owner did not come into compliance within those 60 days and has been receiving a fine of $200 a day since May 21st, 2022. As of today, the property has accrued a total fine of $800 over 4 days, with the 4 different
That's $800
violations.
per case.
Correct. With the 4 would be a total of
$200 per day?
Yes.
So the property, on all 4 cases, the property remains in violation.
That's correct.
And how it remains in violation is because he didn't get his permit.
That is correct.
Has he applied for one?
I haven't seen anything in the system for any application for permits.
Anything further?
No, sir.
What do you have to say, Mr. Coleman?
Insanity. It's amazing that they come up with current pictures today on some issues, and they come up with the original pictures on other issues. This is nothing like it.
This was today.
Those trailers were there today?
This is just about permits.
Okay, so I'll focus.
These are 4 different permits you were required to obtain.
Understand. I went on to get the original hearing video, which is online, and these 4 things were not addressed. In my memory, and there's no notes of it, I had 90 days to do it, or 3 months. We didn't talk in days then. I had 3 months, and it got down to 2 months. Everything else, you go on the video, they have, and they don't have these, and they're combined to 4.
So your defense is that my order is wrong?
Your order, I think, was right. I think they interpreted it wrong, and the films disappeared.
So you're saying we've got the disappearance of the tape like in Watergate?
Much more insane than that. That made sense.
Because my order said 60 days after March 21. That's the order.
On these issues, then I'm wrong.
Permanent.
Okay,
so that deadline is passed. City's case is that it's 4 days. You know, here's the thing. I'm trying to work with you, but I need you to work with me. This hearing was a long time ago.
2 months.
And it was a matter of getting 4 permits. We're sitting here on May 25th, and you haven't applied for one of the 4 permits yet, have you?
Have I applied for them? No.
Okay.
Have I tried to? Yes.
What's the difference?
The difference is for the roofing inspection, I went down there and I needed paperwork and everything, to prove the kind of roof to get the permit on that issue, which I got. It still thought I had 3 months. On the dock, and we're starting backwards, my next door neighbor was or is going to buy this place, and there was a variance on the dock that it was too close to his property, but if he included this in his property, there may be some chance of changing it. Again, I thought I had another month. The concrete, that is impossible for me to correct. They want me to remove the concrete. I mean, really? It's a ramp to the lake, which I own a couple hundred feet out into the lake because the property is West County property.
Here's the thing. This matter we've got tonight is not about whether you like the code. It's not a matter whether you like code enforcement.
I have no problem.
This isn't really whether or not you like my order or not. You had the right to appeal that order if you didn't like it, and that did not happen. So we have 4 orders, and I'm going to find, because I don't have any other choice, that they remain in violation because you did not, you didn't get the permits. You haven't applied for the permits. You had 60 days. If you had said to me tonight that on the 59th day you would come in and applied for all the permits because you thought there was 90 days, that'd be one thing. But we're here on the 68th day, 65th day, and there was nothing that happened. So what I'm going to do is I'm going to impose a $400 fine. That's at $100 a day on each case. So that's 400 times 4, okay? Could have been 800.
Could have been $1 million, wouldn't be surprised. Sorry.
You are not helping yourself.
I am not.
Because you're in control of this. I'm just telling you, you're in control of your own
We're starting this
destiny.
case backwards. We should have gone originally.
No, we're not.
Okay, we'll get
We don't go backwards. We're only here on a very narrow issue, and that is, did you comply with these orders? That's all we're here on tonight.
No, sir, I did not comply.
Okay, so I'm going to order that it's $400 for all of these cases, per case, and it's going to continue at $50 a day. I'm giving you a break.
Again, sir, thank you.
Okay, so those 4 cases. Now, again, you do what you want to do, but I'm telling you, you get your fanny in here and you get these permits, because right now, these things are running. Okay, the last case is DEL 22082. And this one has to do with graffiti.
Oh, that's the last.
Which, you don't need to show me the slide again. I saw it.
My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is a Massey case number DL 22-082, City of Deltona versus Thomas Coleman. Property address is 1835 Twin Oak. Parcel ID number is 812-800-000-070. Statutory requirements for this notification of this hearing have been met. Notice of hearing, notice code violation were sent certified mail to the address listed with property appraisers. In addition to, both notices were posted at City Hall 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be accurate portrayals of what I observed the day they were taken. It was ruled on March 21st, 2022, the property owner was given 14 days to comply. Excuse me. The owner did not come into compliance within those 14 days and has been receiving a fine of $100 a day since April 5th. As of today, the property has accrued a total fine of $5,000 over 50 days. The city is requesting the fines to continue, $100 per day.
Mr. Coleman?
Excuse me.
When I came here, and I didn't know, last hearing, I only had a couple days' notice costing me, I didn't pick up my mail. So those pictures, again, are old pictures. Prior to this, I was charged with the graffiti. I talked to the code compliance guy. I said I wanted to keep it. He said you couldn't. So I covered it up.
You wanted to keep the graffiti?
Well, just, yeah, because that's me. I wanted my picture, and he wouldn't do it. But anyway, so I did what he, at that time,
Can you show me the pictures of the graffiti again?
They're not current.
Well, that's what we're going to, hang on. I'm going to let you speak. I just want to see, you know, because you just said something I find interesting.
I'm sorry, one second.
There we go. When did you take that picture?
Actually, these pictures were provided to us by VCSO. I do have current pictures.
Is that still on the property?
It is covered, but it's not, you can still read it through the paint that he put on there. And it was advised to him at the last hearing that the paint should have to match the building in order for it to, I guess, cover appropriately, according to Mr. Levitt. You can still see the words.
Okay, so I've got 2 pictures. One says womanizer and drug dealer. Has that been painted over?
Yes.
But it's still visible?
Yes.
The next one says Tom is a bestiality, crackhead, and then a really nasty thing. Okay. So that's been painted over, but you can still read it?
Yes, you can still see it.
Compliance means it's painted over so you can't read it?
Correct. It has to be covered.
Okay. What do you say?
I say this violation is like double jeopardy, might not be the right term. This was before all these other little piles of poo got in my life. At that time, this was not on there when this started. These were covered up. The compliance officer, it should be a record, came by and said that it was in compliance. Not that the paint had to match, not that, the script was wrong. That at that time, with nothing changing, he said at his level it was complied, and I didn't
Do you
do
know
anything different.
who that person is?
They should have the record of it.
No.
It was one of their people. I don't know. Don't they have a record of the property and violations?
Okay, so let's take a break. You may not be done. Does the city have any record of someone going out and telling this gentleman that this violation was in compliance?
I do not have a record of that.
Okay, keep going, sir.
That was not today. That's all gone. Now, nothing is. Can we have a continuance to next week and there's other issues?
Okay, this is the last case that have on this property. Let me ask one more question. When's the last time you inspected this property for this violation?
I was out today.
Okay, and tell me what you saw with regard to this violation today.
There was paint over the writing, but you could still see the writing through the paint. It wasn't covered completely.
Only on the back side.
So we've got a white wall with red spray paint on it.
That's correct.
What kind of paint was used to cover it up, or attempt to cover it up?
I don't know.
Was it same color? I mean,
No.
it was white?
No, it was a white color, yes. I have pictures. But it was a white color. It wasn't a dark color.
Okay, you have pictures?
Yes.
Because they're not in the file.
I have pictures that I took today.
Can you put those up?
Yes.
So it's a gray paint?
Mm-hmm.
Okay. When did you do that, sir? Did you do that? Did you attempt to do that?
I did attempt to do that. Like I said, for whatever reason, I would leave it there, but the code person said, you got to change it or cover it. I covered it. Nothing had changed. He accepted it, and nothing has changed since this pile of poo started. So I was
the only pile of poo we're talking about right now is the graffiti.
Right. That's the only pile I'm talking about. I'm sorry. That's all we're talking about. Now, this was just one little pile.
Okay, so here's what I'm going to find. When did you try to do that? When did you do that? When did you put that gray paint on?
Before all this started.
No, it's a simple question.
A date when I put it on there? I don't remember the date I put it on.
Was it yesterday?
No, it was months ago, before all this started. This was a separate issue long before this started. Just looking at the graffiti issue.
Well, that doesn't make any sense because I've got pictures in the file that was presented to me at the last hearing that don't look like this. They're the graffiti with the red on the white. So that's just not a fair and accurate and truthful statement.
That is accurate and true.
Okay, well, you can reach your conclusion and I can reach mine.
Well, I'm going to ask her to take the picture today of womanizer on there.
I've got the pictures that are right there for the pictures that the officer took today. We're looking at them right here.
Okay, yes, I agree that was today, but there's no graffiti. It's covered. It may not be covered to their standards, but it was covered to the previous code violation guy, his standards.
So this question for the city, you're saying that's not in compliance?
No, it was the paint is supposed to match the building. Everything's supposed to look like it was originally.
Okay. Okay.
Sir? Again, it may not be to their compliance, but it was in compliance with the previous guy that they don't have a record of.
Well, if you'd given me his name, I'd be a lot more persuaded.
He didn't work for me.
Okay. All right, I'm going to find that you did make some efforts to bring this into compliance, but it's still in violation. So I'm going to order that there's going to be a $500 fine. I'm going to abate the running of that fine for 10 days from today. And if that's not painted correctly, to remove all that so that it's one color, it matches the wall, it complies with the code, then the fine's going to start running 10 days from now at $100 per day.
Yes, sir.
Okay. Thank you, sir.
Thank you. Have a good evening.
You too. Okay. Two. Okay, we got two more cases, I think, last but not least. 779 Tulip Street. These are cases DEL 22090 and 088. So let me get a chance to get there. Two Massey cases. We got public nuisance and accessory structure. 088 is public nuisance, 090 is accessory structures.
Okay. My name is Kristen Coulter. I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22088, the City of Deltona versus Elizabeth A. Mars. The property address is 779 Tulip. The parcel ID number is 813-003430-190. The statutory requirements for this notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on 4/27/22 that the property owner was given 48 hours to comply. The owner did not come into compliance within those 48 hours and has been receiving a fine of $250 a day since 4/30/2022. As of today, the property has accrued a total fine of $6,500 over 26 days. The city is requesting that the fines continue at $250 per day. The city has decided to move forward with abating the property.
But has not yet.
Not yet.
Okay. Has there been any improvement?
It depends on the day.
What does that mean?
So some days are tubs of empty cat food cans, bags of soda cans.
Well, compared to where it was when these pictures were taken at the time that we had the last hearing, have there been changes or improvements?
So that's from the 15th, and the other pictures are from today.
Is it like a moving target? There's some things that are moved, and then there's new stuff that shows up?
So some things disappear and new things replace them. It's hard to define whether there's improvement because it really does depending on the day.
Okay. So is anyone here, is Elizabeth Mars, or are there any representative of the property? If you could identify yourselves, please.
I'm Deborah Douthit.
I'm Jamie Skinner. I live in the residence.
So are you owner or tenant?
I'm kind of the owner, I think. My mother is Elizabeth Mars, and she's deceased.
Okay.
And there's a trust, and the house is in the trust, and I'm the owner.
Okay. And ma'am, you are?
That's my daughter.
I live in the residence.
You live there?
I'm her daughter, yeah.
Okay.
She's the only one that lives there now. My other daughter died a year ago, June. And my husband that was living with me and my mother died. My mother died in October last year, and my husband died 6 months before that, and my daughter died 6 months before him. So I've had 3 deaths, and her husband's gone to jail. My other daughter's gone to jail. I'm left with nobody but me and her cleaning up this yard. And it's been a process of like 20 years of everything just getting accumulated, and I had to go they stopped recycling, and we had tons.
One at a time, folks. I can't hear you both. We need to have just one at a time.
We just had a ton of stuff in the backyard, like washers would break, and I've been in Cape Canaveral since 2016. My husband was living there, but he was 70-something years. He would be 75.
So let me understand this. This nuisance, all these accumulations that are there, what I'm hearing the city say is that some of it goes away and then new stuff appears.
Yes, that's true.
So that's not
true.
good. Why is that happening?
Because there was
one at a time.
Shush. There was 13 people in there in 2012. I graduated from Daytona State. I had all 6 grandkids, 3 daughters, 2 son-in-laws, and a husband, and 20 cats. I have a colony of cats. I don't know what to... I had a buyer for the house. He wanted to come and clean it all out. I have all of their stuff in there. It's hard to get rid of people's stuff because my daughter has 2 kids still alive, and I don't know what she wants to do with them. The other daughter is in jail, and she has stuff in there. I've been throwing it away. I've got a dumpster bag out front. I've had people, I've paid people like over $1,000 to move stuff. There's a whole bunch of, everybody told me, all code enforcement told me all the years I lived there was it had to be behind the house, the face of the house. And there wasn't a problem because there was a forest next to the house. They just built the house on the forest that was supposedly never supposed to be.
All right, ma'am, I hear you, and you've had a tough time. I get it.
Yeah, I'm
But you got
tired.
neighbors. Let me finish. You
Okay.
got neighbors. No, ma'am, I'm talking now.
Okay.
You got neighbors, and you got a mess there. I wouldn't want to live next to that. And I gave you some time to fix it. It's been there for a long, long time.
No, I called and I got permission. They told me I could put my stuff outside because I had to move it outside to go through it to get it out. They said I could do that. And they said I told them I was moving. I called up code enforcement. She said, I don't know why you shouldn't be able to do that. You should be able to do that. I said, okay, well, that's what I'm doing.
Well, how much time do you think you need to come to bring the property into compliance, ma'am?
I'd say a good month, at least.
I'd say about a couple of months.
I'm old and I've got a hammer toe. I need to have surgery on and I can't do that and work and
she's got,
every day I
One at a time, folks.
When I don't work, I am at that house working.
So, ma'am, you live there. How much are you helping remove all this?
Huh? It's a continuous thing. This is never the same.
That's what the city said.
Right. It continually gets better. And then
But my
sometimes
question
it's
was,
worse.
are you helping to remove it?
Yes.
How?
Well, the recycling, y'all stop the recycling.
One at a time.
Y'all stop the recycling, but I continually get people that come and get the recycling. So yes, we do pile recycling up out there on the side of the house, and I was trying to get it removed. So that's why there are cat food cans there. because
Okay,
I don't want to.
here's what I'm going to do. I'm going to waive the fine through today. I'm going to give you 10 days to bring that property into compliance. 10 days, or the fine's going to start running at $250 a day. And the next time, if it's not brought in compliance, I'm not waiving the fine.
How do we bring it into compliance?
That's up to you. You've had, in my opinion, you've had enough time. You got 10 days to bring that property into compliance, or the fine will run at $250 per day. Okay. So the second case is accessory structures. Here you go.
We got another case. There's 2 cases.
Officer.
My name is Kristen Coulter. I'm employed by the city of Deltona as a
Ma'am, can I ask you a question on that? If the city could help you out and put a dumpster there, would that help you get everything loaded up and you can get it out there?
Absolutely. I have a
Okay.
dumpster bag out front.
We'll see
but
what we
it's
can do to
cost-
help you out.
That would awesome. That would be awesome.
Yes, absolutely.
Great. That's fantastic. I appreciate that from both the city and from
Oh
you.
my God, I could cry right now.
Okay. All right. Next case is DEL 22090. This is accessory structures.
My name is Kristen Coulter. I'm employed by the city of Deltona as a code compliance officer. This will be Massey case number DEL 22090. The City of Deltona versus Elizabeth A. Mars. The property address is 779 Tulip. The parcel ID number is 8130034300190. The statutory requirements for the notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on 4/27/22 that the property owner was given 7 days to comply. The owner did not come into compliance within those 7 days and has been receiving a fine of $150 a day since 5/5/2022. As of today, the property has accrued a total fine of $3,000, $150 over 21 days. The city is requesting that the fines continue at $150 per day.
Okay, let me understand a little bit more about this violation. So he says accessory structures. Stop right there. Are those what we're talking about?
Yeah, the 3 sheds in the back.
Okay, so what does the property owner have to do? What do these nice ladies have to do to bring it into compliance?
So the sheds they're all in disrepair, so they have to either be repaired or removed.
I've emptied 2 of them.
So the violation is that they're in disrepair. So it'd be hard to repair a shed, as you know.
Right.
So it'd be easier for you to just remove them.
That's why we're emptying them. That's why all this stuff's out front.
Yeah.
It was all over the backyard, but we had to mow, so we had to move it. It's like a,
All right, so as I understand to come to compliance, you just got to get rid of those
It
sheds.
used to be full. This backyard was full. It had 15 washers and dryers back there. It had both sheds, those 2 sheds were full. I've had multiple people come in and strip them because I wasn't there, my husband died. And it's just that people have been in and out my house for 4 years, and I wasn't
How much
there.
time do you think you're going to need to get rid of those sheds?
To pull them down?
Get rid of them. Tear them down, and then not leave the stuff there. You got to get rid of them.
I can tear one of them down, and dumpster will help. Yes, a dumpster would help. 2 of them are almost empty.
Okay, here's what I'm going to do.
They got broken glass.
I'm going to waive the fine. I'm going to give you 10 days to remove the sheds or the fine of $150 per day. It's kind of like the last time. In other words, now we understand what I've done here tonight. I'm not imposing a fine.
I understand.
I could have.
I know.
Thousands and thousands of dollars. I'm not doing that.
I appreciate
But I am trying to bring this property into compliance because that's my job.
I understand that.
That's all of our job. So I'm giving you 10 days just like before. Now, the city's going to work with you. Someone from the city is going to work with you to get a dumpster out there. You've got 10 days,
Okay.
okay, to get rid of those sheds. Or then there's going to be a fine.
I appreciate it.
Okay.
Thank you.
All right.
It's awesome. Thank you so much.
Ma'am, before you leave, the main thing is, can you give your phone number to that officer so that way we can get it? to
Yes, sir.
Have a contact number for you?
Absolutely.
Let me get a pen.
Hey, can someone get me a bottle of water? Yeah. Can someone get a bottle of water,
Got one.
please?
Can somebody go grab one? Huh? I don't know if there's any bigger.
If there's not any, it's not that big of a deal. I'm just, okay, the next case is DEL 22068. It's a Massey case. Property address is 930 Radcliffe. Property owner is, looks like Nilda Hernandez and Honorio Hernandez. Officer Bashir, I'm gonna get grief for this. Turksy?
Oh, they found you one.
It's partially drank, you can have it.
Okay, thank you. I know what you're doing. I know what you're doing. We don't have any more public here, right? No more respondents?
No, sir.
Correct. All right. Officer, please proceed. How do you pronounce your last name, sir?
Turkzy.
Say that again.
Turkzy.
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 Yes, Your Honor.
Okay, I apologize, but I just want to get it right.
Good evening. My name is Bashir Turkzy. I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 22068, the City of Deltona versus Hernandez Nilda and Hernandez Honorio. The property address is 930 Radcliffe Street. The parcel ID number is 813030170090. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on February the 27th of this year that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $50 per day since March 30th. As of today, the property is still in violation and has accrued a total fine of $2,800 over the period of 56 days. The city is requesting that the fines continue at $50 per day until the property is in compliance. Thank you.
Any contact from the owner?
Yes. We have contacted the owner several times. They claimed that they were counting on the neighbor to help them with fixing the wall, but the neighbor fell sick and was unable to help them. So
They're not here tonight. Have you any idea why?
no, they're not here.
Okay, I'm going to find that the respondents are not present, still in violation. A fine of $50 per day for 56 days at $28.50. Fines continue at $50 per day.
Thank you.
Thank you. Next case is 2285, another Massey case, our last Massey case, pools.
Go ahead and just present it. You can't find it
The pictures.
Did you put them in?
Yeah.
Ma'am, you can go ahead and proceed.
Okay. My name is Josie Moore Jimenez. I'm employed by the City of Deltona as a code compliance officer. This will be Massey, case number DEL 22085, the City of Deltona versus TBR SFR Orlando owner. The property address is 1088 East Page Drive, Deltona, Florida 32725. The parcel ID is 813-055-260-150. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, which I don't have been marked and exhibits and submitted to Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was entered into evidence exhibits proving proper service and copy of the original magistrate order along with photographs This case was heard on April 27, 2022. The order was signed on April 27, 2022, giving 48 hours to come to compliance or a fine of $250 per day until the property comes into compliance. The property is now 25 days in violation. The property has been in violation since April 27, 2022 to the current date of May 25th, 2022, a total of 25 days at $250 a day for a total fine of $6,250. Based on the testimony and evidence submitted in the case, the city is requesting the magistrate impose the following: the Massey motion still in violation and the fine to continue until the property is in compliance. I'm trying to get you the pictures.
So when was the last time you went out there?
Today.
And?
It's still in violation. They did drain the pool. It's basically, what they ended up doing was, it's a
Why
vacant.
is that not in compliance then?
Well, what happened was it's a vacant property. So what they did was they hired someone to drain the pool, but they ended up emptying whatever was in the house into the pool. So now there's a bunch of debris. They've broken the pool trying to demolish it, which they need a permit for, but
So it's not a clean and sanitary condition?
absolutely not. And I have pictures of that today.
Is property vacant?
I do have pictures here if you want to see them. I printed them out just in case they didn't pop
That's
up.
okay. I'm fine. I got it, based upon the evidence and the testimony you provided. Have you had any contact with the owner?
I have tried. It is a company called TBR Tiber. I did get a phone call from a lady named Sarah Steinberg. She called me yesterday and left me a voicemail message saying that they covered the pool, but she wasn't aware of what they did
But you went out there today?
I did,
It's
yes.
not covered?
Absolutely not.
Okay. All right. Has anyone checked to see whether this property is homesteaded?
It is not.
Okay.
So, and Mr. Reichman, just to let you know, on top of that, the neighbor came in at 5 o'clock this afternoon with some current pictures. What they did is they took some plastic sheeting, just threw it over the top with wood and all kinds of debris sticking out of it. So we have, our contractor will be going out there to board the pool because they've taken part of the fence down.
Okay, fair enough. I'm going to find the property remains in violation for 25 days beyond the deadline at $250 per day for a fine of $6,250 with a fine to continue at $250 per day.
Thank you.
Thank you. Okay, next case is DEL 22-105-2767 Faison Circle. This is not a Massey case. New business, permit.
Good evening. My name is Tyler Russo. I'm employed by the City of Deltona as a co-compliance officer. This would be case number DEL 22-105, the City of Deltona versus Marlene M. Monaco. The property address is 2767 Faison Circle. The parcel ID number is 813-043-340-120. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, unauthorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. The corrective action for said violation is to obtain a permit. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida, 32725. The structure must meet all requirements of city ordinance and must be approved on final inspection. Contact our office with the permit number when obtained.
Okay, let me ask a question. Let me interrupt, sir.
Yes.
This is to anybody in the city. Why does that structure need a permit?
So a construction crew was working with the screening and the wood upon a complaint, which I'll get to when I get to my script. But it's also bigger than 120 square feet as well, and has not been obtained for a permit for that either.
Okay, and I'm not trying to be argumentative, and maybe this would be for, what part of our code, what language in our code says something that, what I'm looking at, what we're looking at, what language in the code says you got to get a permit for that?
It's an accessory structure, and it's above ground, and it meets the definition of a structure.
Perfect. Please proceed.
The statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On February 24th, 2022, I arrived at 2767 Faison Circle upon a complaint from a citizen for an ongoing noise disturbance. During my investigation, I heard some form of construction work going on in the backyard. I was able to get a hold of one of the lead construction workers and ask what was going on. He stated that they were doing construction work on cat kennels in the backyard and that they were replacing the screening in other parts of the kennels. The owner was not currently at the property, and I was able to get a phone number off of the construction worker and explained to her, Marlene Monaco, I was able to explain to her that these structures do not have a permit, and because of the construction going on to the cat kennels, that they would need a permit. A few weeks later, on March 30th, 2022, I was able to talk face-to-face with Marlene about needing to apply for a permit for these cat structures, or their cat kennels. I also got to witness the cat kennel structures for the first time. I found that both of the kennels were big in size, and by the looks of it, they were both over 120 square feet. Over the past few weeks, I've attempted calling Marlene to see where she's at in the process of obtaining this permit, but each time I've called, it has gone to voicemail. As of today's date, no permit has been obtained.
As of today's date, has a permit been applied for?
No, sir.
Okay.
The city would like to request 30 days for the property to come into compliance, or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
What was the fine per day?
$50 per day.
So ordered.
Good, thank you.
So I'm not sure it wasn't any, but he took those pictures before he had permission to be on from the property. That could be a problem. So just, that's kind of thing you want to, he may have. Okay, you understand what I'm saying? Because people get sued for that. Okay. But you understand what I'm saying? I just, yeah. Okay. Okay, next case, 22141, 1805 Snook Drive. It's a question for just in general. Does Officer Laracy just work more days than anyone else? Or is she just meaner than everyone else?
I reserve the right to not answer, sir.
I just feel like we'd all already be home.
It's not just me. My name is Marion Laracy, employed by the City of Deltona as a code compliance officer. This is in reference to DEL 22-141, City of Deltona versus Daniel Strickland. Property address is 1805 Snook. Parcel ID is 813-023-060-180. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Statutory requirements for notification of this hearing have been met. Notice of hearing, notice of code violation were sent certified mail to the property owner, listed with property appraisers. In addition to, both notices were posted at City Hall 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as evidence and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I've taken the day of what I've taken on that day. This case began as a complaint, as in reference to a driveway that was concreted to include the apron without a permit. I have been in constant contact with the property owner, and he's trying to get engineers and everything that he needs to get the permit. It's just been a difficult process. He was actually going to come tonight, but he had a last-minute appointment. We are requesting 60 days for the property to come into compliance or a $50 fine.
How much per day?
$50 per day.
Okay, so ordered. The property still in violation, 60 days to comply, or $50 per day thereafter.
Thank you, sir.
Okay, the next case is DEL 22149. This has to do with rodents.
Good evening. My name is, you ready?
I am ready.
Okay. My name is Officer Scott. I'm employed by the city of Deltona as a code compliance officer. This case will be DEL 22149, the city of Deltona versus Crown Property Acquisition, LLC. The property address is 1223 West Wellington Drive. The parcel ID number is 8130010700200. This is a violation of the City of Deltona Ordinance, Section 18.5, adopting the latest edition of the International Property Maintenance Code, Section 302.5, which states that all structures and exterior property shall be kept free from rodent harborage and infestation. Where rodents are found, they shall be properly exterminated by approved process, which will not be injurious to human health. After extermination, proper precautions shall be taken to eliminate rodent harborage and prevent reinfestation. The corrective action for said violation is to bait the property. The statutory requirements for the notice of this hearing has been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing.
Yep.
All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken.
So I have a question for you, officer.
Yes, sir.
I like your photos. I really like your video. But I want to know how you were able to get those videos.
Oh, I'm getting to the narrative.
Okay.
All right. This case was initiated as a complaint on March 18th regarding rodent problems. I spoke with the tenant who lives at the residence, Jason, and he allowed me inside the residence to take photographs. On April 29th, I contacted another tenant at the residence, Lisa, and she stated she had Aaron's Pest Control out, and they advised extensive rat infestation and could not and they could not access the attic due to the AC duct blocking it. The property owner has not contacted me regarding this case. I spoke with Jason today, and he stated...
Who's Jason?
The tenant. He stated Massey Pest Control was out there on Monday and started to remove the rats. The city would like to request 7 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
So the property's occupied by tenants.
Correct.
So if I'm going to impose a fine, that means you're saying the property's still in violation, but you said that Massey's been out there.
Yes, they started Monday.
Today's Wednesday. So how do we know the property is not in compliance tonight?
I spoke to Jason today, the tenant that lives there.
And he said?
They're still there. They just started.
Got it. That's what I needed to
Getting ready
All right.
to.
Sorry, I didn't catch that the first time. So still in violation, 7 days to comply?
Yes, sir.
Or how much per day?
$100 a day.
So ordered.
Thank you, sir.
Question, excuse me. When you who obtained the photos and the video?
Lisa provided the video.
Those were provided by the tenant?
Right.
Yeah.
That's what you wanted to know about.
Yeah,
Okay.
yeah. That's what I thought he said. Okay, do we have another case of the same property?
Yes, sir.
Okay, that case is DEL 22150.
They would have been here tonight, but they had a death done in family.
Okay.
That's the reason why. So.
This one has to do with a permit.
Yes, sir. My name is Officer Scott. I'm employed by the city of Deltona as code compliance officer. This case will be DEL 22150, the city of Deltona versus Crown Property Acquisitions, LLC. The property address is 1223 West Wellington Drive. The parcel ID number is 813-001070200. This is a violation of the City of Deltona Ordinance Section 18.3, adopting the latest edition of the Florida Building Code Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain permit for the AC work. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was a complaint on March 18th. I spoke with the tenant, Jason, who allowed me inside the residence to take photos of the AC duct blocking the attic access. As of today, I have not heard anything from the property owner regarding this case, and no permit has been obtained. The city would like to request 7 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
So ordered.
Thanks, sir.
Next case, DEL 22151. 3 cases.
Yes, sir.
1602 Providence Boulevard. The first one has to do with permits.
Yes, sir. My name is Officer Scott. I'm employed by the city of Deltona as a code compliance officer. This will be case number DEL 22151, City of Deltona versus Robert and Deborah Tincher. The property address is 1602 Providence Boulevard. The parcel ID is 813-07205-0170. Okay. This is a violation of the City of Deltona Ordinance Section 18.3, adopting the latest edition of the Florida Building Code Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the additions, the overhang awnings. The statutory requirement for notification of this hearing has been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was initiated as a complaint on March 2nd regarding additions to the property. I conducted a site visit and noticed 2 overhang awnings that was put up, one at the front right corner of the house and the other one connected to the shed in the rear yard. According to the pictometry of the property appraisers, it appears the addition was put up between March of 2020 to January of 2021. I was able to speak to Robert Tincher today, the property owner, and he stated he is waiting on engineer drawings to obtain a permit. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
So ordered.
Thanks, sir.
Next case is DEL 22152. This has to do with debris. Same property owner.
Yes, sir. My name is Officer Scott. I'm employed by the city as a code compliance officer. This will be case number DEL 22152. The City of Deltona versus Robert and Deborah Tincher. Their property address is 1602 Providence Boulevard. Parcel ID number is 813-027-7205-0170. This is a violation of the City of Deltona Ordinance Section 38-110, subsection B2, which states that accumulation of waste, yard trash, rubble, and/or debris are declared to be a nuisance and must be abated entirely. So let me pull it up. The corrective action for said violation is to properly dispose or store inside of an enclosed building. The statutory requirements for notification of this hearing have been met by The notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was initiated as a complaint regarding debris on the property. I conducted a site visit and noticed debris in the rear yard under the overhang awning. I was able to speak with the property owner, Robert Tincher, today, and he stated he needs 14 days to come into compliance. So the city would like to request 14 days for the property to come into compliance or a fine of $100 a day.
So ordered.
Thank you.
All right. Officer Scott, you have the distinct honor of believe handling the last case, DEL 22153. Yep. Same property.
All right. My name is Officer Scott. I'm employed by the City of Deltona as a code compliance officer. This case will be case number DEL 22153, the City of Deltona versus Robert and Deborah Tincher. The property address is 1602 Providence Boulevard. Parcel ID is 8130720500170. This is a violation of the City of Deltona Ordinance Section 6618, subsection H, restrictions on trucks and other vehicles, which states a maximum of 2 vehicles may be parked in the side or rear yard. Corrective action for said violation is to reduce the number of vehicles in the side or rear yard to a maximum of 2 vehicles. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was initiated as a complaint March 2nd for too many vehicles on the property. I conducted a site visit and noticed multiple vehicles in the rear yard inside. As of today, there's a boat and a red pickup on the right side of the house and a brown Ford pickup and 3 boats in the rear yard. I was able to speak with the property owner, Robert Tincher, today, and he stated he needed 14 days to come into compliance. The city would like to request 14 days for the property to come into compliance or a fine of $50 today.
So ordered.
Thank you, sir.
Is that all you got?
That's it.
Isn't that all we need, sir? That's more than enough. We are adjourned. Thank you very much, folks.